hear ye, all persons having anything to do before the Honorable Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. First of all, thank you for your patience. We had the inaugural sitting for our newest justice, Robin Toone, this morning, and that's why we are 15 minutes late. I'm Judge Milkey. To my right is Judge Massing. To my left is Judge Neyman, and together we are the panel on all 6 cases this morning. I'm not going to go over the rules. I assume you're familiar with the rules, 15 minutes per side. Because that's not a lot of time, we would urge you to cut to the chase to the extent possible. We have read the briefs and the relevant portions, at least, of the record, and are familiar with the facts and the legal arguments. So again, please cut to the chase. If at the end of what you have to say, there is still time on the clock. There is no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day. It's a juvenile case, 2023 P 212. I would remind the parties that the portions of the case, most importantly the names of the parties, are impounded. That means the party and, of course, the victim. And if we could first address the motion to strike that we just were handed. I understand that you have not had time to review the CD. Obviously, you are going to get that time to look at it. It is our hope, if you don't object to the authenticity of the of this CD, that there will be an agreement, because one way or another it either has to be certified or agreed to.
Right. The Commonwealth and I just discussed it, and he will, if this court allows, be filing just a supplement stating that it was copied directly from the clerk's exhibit and then sent directly to this court. And so I have no objection as long as there's a certification and assertion that it's directly from the clerk's office, unchanged.
When you get that document, and assuming you are willing to withdraw the motion to strike, that would be a nice formality too.
Okay, I'll do that. Thank you. May it please the court, Elizabeth Caddick for the juvenile. The 3 issues in this case all revolve around the fact that the Exhibit 6, the SANE report, was not properly redacted. The defense was that the juvenile believed, and reasonably believed, that Eileen, the pseudonym, gave consent to the sexual contact. And so the fact that the word assailant occurred 5 times, or 7 times in the word assault, occurred 5 times in the report, was prejudicial, because the issue wasn't identity. It wasn't as if an assault was conceded and the identity was at issue. What was at issue was whether there was an assault under the law at all. And also the second argument had to do with no a factual basis in the medical records for the SANE examiner to check off that force was used. There's nothing in her report elsewhere that force was used. I want to address whether it's preserved or not issue, but on that issue that you're raising right now, the nurse testified. She testified. The victim described being held down. I mean, didn't the victim speak to her? Isn't that? I mean, it's her memory that that's what the victim said.
I don't quite see why you say there's no basis for that.
Because there's nothing in her records that document that. She does document.
And that happens all the time, though. Like, that when a police witness testifies, they always say something that's not in their report, and they're always cross-examined, that's not in your report. But it is on the record. It's checked. She checked off the box and she wrote it in.
Right. Well,
where else would she record it?
So I do agree that there's two separate issues. One is her testimony in court, and one is the record. And so since there was an objection to Exhibit 6, and since it's a number of times in the exhibit, and Exhibit 6 was objected to, that there's no basis for her to check that off, that it was her thinking that Eileen woke up to someone on top of her was the same as using force and being held down, and that was improper. The fact that medical records can come in under the statute and the rules of evidence are only when the purpose of the documentation, the purpose of the hearsay, is primarily for medical treatment, and only incidentally does it go to liability. In this case, there's no evidence that the documentation by the same nurse was for a medical treatment. It was for evidence collection for the report of the sexual assault. The first argument has to do with, of course, the words assault and assailant.
Let me ask you about that.
Yeah.
You state in your brief that the issue is preserved, and
Yes.
you cite to Volume 2 of the trial transcript at pages 85 and 86. In looking at those pages, I see that there's an objection where defense counsel asked to be heard at sidebar. She then states at page 85, I do have some certain objections to certain portions of it. And then the transcript largely says indiscernible. And then at page 86, defense counsel says, so the understanding of this is it doesn't go to the treatment, it's evidence collection. That's the purpose of it. The prosecutor responds, defense counsel says, okay. And the judge says, is that the only portion you're trying to object to? And defense counsel says that is the only portion. That's somewhat vague to me, and I don't see that in the transcript where there is a specific objection to the use of the words assault and assailant that you're now addressing on appeal.
Okay, so on page 6 of my reply brief, I do quote from pages 84 to 87. And when the defense counsel objects, she states that she hasn't gone through all of the exhibit yet to redact the words in it. And the DA says, in the meantime, can we show the section she's not objecting to? And then she says, I believe it's this page, one page, right here, Your Honor, this is in the section of Form 4, where they're supposed to record essentially the impressions of the patients and their observations as anything important to the treatment. And so
And then the defense counsel says, respond to that, well, that doesn't go to treatment. I mean, so it sounds like she's objecting to it.
Well, I agree that they're holding up papers that aren't identified. She says, well, I'm objecting to this, but
She specified Form 4, and I'm looking at Form 4, which is at Record Appendix, page 20, and I don't believe that's a page that contains the words assault or assailant.
Right, she didn't object to Form 4,
Okay.
and that is the observations. That's objective information that that Nurse Pratt observed, and so it's clear from that the DA didn't dispute that they hadn't finished redacting Exhibit 6 and said, well, okay, I'll at least admit the one page she's not objecting to, and she mentions Form
And did,
4.
before the exhibit went to the jury, did defense counsel come back and say, okay, this needs to be redacted at any point in time?
She did. She objected and said, I haven't had a chance to redact it. We had an agreement, or there was an understanding we were going to redact it first, and the DA never disputes that.
Did she go back then, before the evidence went to the jury, and redact it, or seek to have it redacted, or note to the judge that this hasn't been redacted and I'm objecting for the record?
Well, she didn't object a second time. She objected then, and the judge said, I'm admitting Exhibit 6. I note your objection. That was within those pages that we're talking about, 84 to 87. So the objection was noted. Also, it was immediately after that presented to the jury on a big screen. So they already saw it. And of course, it was additionally prejudicial that it went back to the jury. But the court already overruled her objection.
I want to let you get to the heart of your argument. I'm just going to ask one more
Yes.
question. At page 86, the judge says, is that the only portion you're trying to ostensibly object to? And defense counsel says, that is the only portion. So what is the only portion? Is it one page, or is it all of the pages that contain the words assailant and assault? Because if it's the latter, we're not really matching up here.
Right, and we don't know what she's holding up, but she also doesn't dispute that what the DA said, that she's not objecting to only one page, Form 4. So that's what we have. And if I thought it wasn't, I didn't think it was unclear until the Commonwealth's, I believe, clearly misunderstood and thought she was only objecting to Form 4 and not to everything else, which makes absolutely no sense because Form 4 has nothing prejudicial in it, but almost every other page of the rest of the exhibit does have prejudicial information in it. And also the law is so clear that you can't use the words assault and assailant without it being redacted. So if a rational reading of the transcript is that she objected to everything but Form 4 because it had not yet been redacted. She wasn't objecting to the whole thing. So the fact that in this case where it's an assault, a consent defense, the fact that there's assault and assailant and is presented by someone who goes as an expert, and then we already discussed the hold down, force used, which.
So is it the hold down, force used? You seem to be arguing two things. One of them is that came out of nowhere, and the other one is that it doesn't have to do with diagnosis and treatment. Isn't the case law pretty liberal in allowing in stuff that talks about how somebody got injured? Exactly,
and if it had been for medical diagnosis and treatment, the hearsay was for medical diagnosis and treatment, then and it was just incidental to the liability, that would be something else. But because the whole form was in there unredacted, and that it also includes, this was reported to the police, which shouldn't, by case law, should not have come in. And it's if she had a head injury, or she had broken bones, or she had.
But isn't part of the purpose to check to see if she has injuries or broken bones? So isn't the fact that she told the nurse that she was held down, wouldn't the nurse want to check for bruises and abrasions and stuff like that?
Right. So my argument is that if it's real, my argument is that Nurse Pratt tried to put a square peg in a round hole, that the check marks only said force, hold down. And what she included in her records were that Eileen woke up to someone on top of her. And so she to put that in her little check mark, she checked off force used, held down. And so
And then she wrote next to it, woke to person on top.
yeah, and so it's just unreliable hearsay. And the whole reason that medical records are allowed to be admitted is because it's assumed that it's reliable hearsay, that a patient would want to give proper information and make a proper complaint because they want to be properly treated. Well, according to that form, she said she woke up to someone on top of her, and the nurse puts down force held down, force used. And so that's the argument. And according to DeMonte, it's only when the issue of liability is incidental to the main purpose. So it says medical records that relate directly and mainly to treatment and medical history of the patient are admissible even when, quote, incidentally, the facts recorded may have a bearing on liability. And so the argument is that comment of she woke up to someone on top of her does not directly and mainly go to medical treatment and history. It's really for liability because she's trying to check off a form that's for liability, and the courts have recognized that, which is why it should be redacted.
You also argue in your brief on page 24 that Form 5B, which is the evidence collected inventory, has nothing to do with diagnosis and treatment. Are you saying that Form B shouldn't have come in?
Oh, Form, or 5B.
5B, yeah.
5B.
Which shows where, where swabs were taken from.
Right. Well, I'll check 5B, but the argument has been that it should have, not that the form should not have come in, they should have come in redacted. So 5B.
So you have no objection to the inventory list of coming in to show where the victim was swabbed?
Evidence collected.
As long as it
Right.
doesn't say victim or
You're right.
assailant.
Evidence collected inventory list. Well, that's certainly not a medical term. That's certainly not how medical people describe what testing they've done, what
But isn't that independently admissible to do, like, for the chain of custody of the DNA evidence and stuff like that?
No, not through the medical record.
Well, not through the person who made the collection?
Right, for the criminal liability. Well,
So,
right. The fact that it was, so the evidence collected inventory list, there is case law that says that should be redacted because that's not part of medical treatment and diagnosis. And all this segues into the failure to give the instruction pursuant to Dargan, because what we have is all of these instances of liability in the evidence that was presented to the jury on the screen and back, in the jury room, and the instruction that the court in Dargan said should be given when requested. It's a should, and it was specifically requested. There was a written request. It quoted from Dargan, and the court denied it, and that was error and particularly prejudicial considering the evidence in this case.
Counsel, thank you. I see your time is up. My colleagues have no further questions, so we will hear from the Commonwealth.
Good morning, Your Honors. Nathaniel Stetson for Middlesex on behalf of the Commonwealth. May it please the
Could you
Court.
speak up, please?
Yes, Your Honor. Nathaniel Stetson for Middlesex on behalf of the Commonwealth. May it please the Court, I'd like to begin with the standard of review for the redactions. I don't believe it is possible to read the transcript the way that the defendant Juvenile reads the transcript to maintain that claim of error is preserved. It is clear from the transcript that the
Is it clear what portion they're talking about?
Form 4, Your Honor, and there is also discussion at length of the basis of the objection, which is that it is not admissible for as a medical record because it is insufficiently diagnostic and treatment-related in nature. And that's the basis of the objection that defense counsel registers. Defense counsel at trial never mentions anything about the words assault or assailant as they appear on the form. And I would...
Do you acknowledge that those words shouldn't have been there in front of the jury?
I do, Your Honor.
So why is it, and I mean this as a serious question, not rhetorical, why is it that we continue to see cases where proper redactions are not made, where all parties agree that words like that should not appear in these forms, and yet we see case after case in which they do?
I don't know for sure, Your Honor, other than the press of trial. I will point out that in this case, unlike in Dargon and in several of the other cases, many redactions were made. And it's a little bit difficult to see in the record appendix because those trial redactions appear to have been made with whiteout, and the redactions for the purposes of the brief and the record appendix appear to have been made with a black box via software. But in the title of those forms, in large bold print, the word sexual assault evidence collection form is redacted. You can see the white spaces where something's been redacted in the titles of those. And it was missed in the smaller print in these, the headings for the little boxes for each section. So my suspicion is that where the print was smaller, where it was against, I think, not a white background on the originals, it may have been that whoever was performing the redactions missed it. In any case, it was missed by both sides. It was not objected to, and so this court should be reviewing for substantial risk of a miscarriage of justice.
How much of a difference does that make? Can you only win if we look at it as a substantial risk, but not if we look at it as prejudice?
The prejudice to the defendant was minimal given the strength of the Commonwealth's case overall. So I think we can win at a prejudicial error standard. Obviously, it's much closer. But given all of the defendant's many admissions to various people at various times, given the testimony of the victim, given the testimony of the nurse, given the first complaint testimony of the DNA, the Commonwealth's case was strong enough to overcome that prejudice. With regard to the redactions as well, I would just point out to the court, there are cited in the brief a number of other cases where worse facts for the Commonwealth, cases where there was no redaction of those forms, were still not found to have created a substantial risk of miscarriage of justice. This case is a better case than Dargon and those other unpublished cases that I mentioned. Turning to the medical nature of that Exhibit 6, the defense raises objections to both the form itself, which is preserved, and the nurse's testimony, which is not preserved. There was no objection to the testimony at trial being for medical purposes. As the court knows, those references to being held down, body weight used, those are within the very, very broad ambit of what is considered relevant to medical treatment. There is a case that I very recently stumbled across, which is Commonwealth versus Hoime, 100 Mass Appeals Court 266, 2021, that I can provide to the court and to
What was the name?
56?
Yes, Your Honor.
What was the name again?
Hoime, H-O-I-M-E, in which that court found that the fact that the defendant was a male acquaintance of the victim was sufficiently related to medical diagnosis and treatment as not to raise an issue. The court didn't explain its reasoning in that case. I suspect it may have been for purposes of sexually transmitted infection or something of that nature, or further evidence collection, perhaps from the defendant. But Dargon itself reinforces that very, very broad scope of what is appropriate for medical examination and treatment, and says that the dual purpose of the form and the interview does not preclude the admission of either the form or the interview testimony. It's not inadmissible, says Dargon, just because the victim describes how they received their injuries.
Let's talk about the Dargon instruction.
Yes, Your Honor.
Why on earth is the trial prosecutor objecting to that instruction? The SJC said in footnote 13 of that case should give it upon request. They ask for it verbatim from footnote 13. Why object to that?
So the circumstances of Dargon are very different from the circumstances in this case that give rise to that instruction. So in Dargon, the
Did the SJC in Dargon put limiting principles into that suggestion? It wasn't a suggestion, it's actually more of an order, isn't it? Did they say, well, some circumstances, some cases you might not want to? I read it as a broad command. When a SANE kit is introduced as an exhibit or when testimony is offered concerning the SANE examination process, the judge on request should, and they go on to explain, you give a Dargon instruction.
No, there's no limiting language other than that. I will point out that the court did say should give the instruction, which could be read to mean that there is still that broad discretion.
So here you have a SANE nurse testify, you have a SANE kit put into evidence, you have all these pages of these medical records which have, quote unquote, the SANE imprimatur on it. Why object to the giving of the instruction?
I don't know for sure, Your Honor. I don't think the objection was necessary. I think the Commonwealth's case was strong enough to prevail had that instruction been given, certainly.
Well, the Commonwealth's case should be strong enough to prevail with a Dargon instruction, right?
Right, I agree.
The judge, when the judge said she wasn't going to give it, she said, it will be covered in some of the alternative jury instructions that we provided. Were there any other instructions that got near to the Dargon? You don't cite it in your brief. I assume that there weren't. Yeah.
And only on the logic that the evidence that a complaint was made, the evidence that an investigation was carried out, is not evidence that the crime itself occurred.
Was that instruction given?
That instruction was given. That was a standard instruction, not an alternative instruction, but it was given. And again, I would just point to the vast difference between Dargon, in which the nurse, in that case, testified that nurses are paged by hospitals when there is a sexual assault patient that presents to the ER, and they coordinate the patient's medical care relating to the sexual assault. That was the testimony in Dargon. In this case, the testimony didn't use the word sexual assault, and it didn't even assume really that anything had occurred. The nurse's testimony was, I would suggest, artful in that it refers to going and doing an evaluation, providing care, and then based on the patient's account of the story, deciding what evidence to collect. And that's the basis for those forms. That's the basis for the nurse's testimony. And so for those reasons, I would suggest that if there was error...
Would you say that the evidence collected inventory list is admissible under the medical records exception to hearsay rules, or there's some other reason that it comes in?
It would come in for purposes of chain of custody, in particular, the DNA evidence is necessary for that. But the fact that it documents where evidence was taken from also means that it's necessarily documenting where the defendant made contact with the victim, which means that it is documenting to some extent the injuries. So I think it's admissible under both doctrines.
I have just a very specific question. On page 23 of your brief, you argue that the strength of the Commonwealth's case was increased by the testimony of the first complaint witness because it was consistent with the victim's account. Why isn't that statement you're saying that the first complaint testimony served as corroboration of what the victim was saying, and isn't that itself a no-no?
So the first complaint evidence is admissible only for the limited purpose of essentially circumstantially corroborating what the victim is testifying to, right? And so in this case, it accomplished that purpose.
I think when you're getting into substantive corroboration, you may be on shaky territory, at least in the theory of the first complaint doctrine.
If there are no further questions from the panel. I will
Hearing
otherwise
none,
rest
thank
on
you
my
very
briefs.
much. The case is submitted.
Thank you, Your Honors.
Our next case is 2023 P109, Commonwealth versus DEBRA MILESI. And if I mispronounced that, my apologies.
Good morning. May it please the Court. Jalanpan Nakam on behalf of DEBRA MILESI, addressing the first issue of consciousness of guilt. The evidence as it was presented did not warrant such an instruction. The judge essentially gave vague instructions to the jury that they could consider certain evidence that as it came in through the trial that was evidence of consciousness of Ms. MILESI's guilt. The record does not support such an instruction.
So just to start with our favorite subject, standard of review, my understanding is there was no objection to the giving of the consciousness of guilt instruction, so our standard of review is whether there was error, and if so, whether it created a substantial risk of a miscarriage of justice. Is that correct?
That is correct, Your Honor.
Okay.
The evidence...
Was the content of the instruction the same as the model jury instruction?
In essence, it was, Your Honor, except that the judge did not provide specific conduct or evidence that came in through the trial that would guide the jury as to what it could consider as it evaluated and deliberated on what conduct constituted, would have warranted the consciousness of guilt instruction. So we are left to then speculate as to what that conduct is.
What is classic consciousness of guilt evidence?
I'm sorry, Your Honor, I didn't hear that first part.
Sure. What is classic consciousness of guilt evidence?
Flight from the scene.
Flight from the
Commonwealth
scene.
v. Vic.
What's the other one?
Providing false or fraudulent or misleading information.
Wasn't
perhaps.
there testimony and evidence in this case as to both, assuming the jury credited it?
There was no, well, taking the first piece of it, which is, I think that the judge insinuated through his instruction that the fact that Ms. MILESI drove some distance was evidence of her consciousness of guilt. If we look at how the evidence came in, we have two civilian witnesses who may or may not have seen, frankly, the actual impact of the car with the decedent. What we are left with then is testimony from the police officer, which is corroborated by his cruiser cam. I understand in my brief I wrote that his testimony controls. Really what I should have said was that the cruiser cam was what should have controlled. And that is Exhibit 7, which I understand has been transmitted to the appeals court from the trial court recently, which shows undisputedly that when the police officer pulled up to the scene, Ms. MILESI was parked. She was not in motion. It was only when the cruiser came up behind her that she then drove forward some distance to a and came to a complete stop. So there is no evidence of her flight from the scene. Now, I understand that there was a civilian witness who pointed to her when the police officer did arrive. That is partially visible as well in Exhibit 7 in the cruiser cam. And that evidence or that testimony itself does not indicate that he was suggesting that she fled from the scene. As a matter of fact,
What about the eyewitness who was asked, did the driver of the vehicle leave after the police arrived or were visible? Answer, yes.
Your Honor, if that testimony suggests that she fled from the scene, that is not, the cruiser cam completely eviscerates that testimony because the car was parked. It was not disputed. The jurors saw this video. The car was parked in the middle of the street. So it stands to reason when the police cruiser came up behind the vehicle that the vehicle then pushed forward ahead before coming to a complete stop. As I think we can surmise that the police officer, either she saw the police officer or he gave her instructions, the sirens came on, what have you. In any event, the car moved only after the cruiser came up behind her car. As to her statement to the police.
And
which-
can I just clarify? And you're saying the evidence was such that the jury could not have concluded that the car traveled some distance before Officer Baker came upon it?
The car traveled some distance only after the cruiser arrived. What I'm suggesting that it's consistent with somebody who is following direction from the police, not necessarily fleeing.
But the issue
because she came
isn't
to a
could
stop.
the jury view it in the defendant's favor, it's did the jury have to view it because it was uncontested and
There's no reasonable inference that could have been drawn from the evidence as it came in that she fled from the scene, given the cruiser camera, given the testimony of the civilian witnesses. I think that there may have been some confounding of testimony by one civilian witness who said that she drove from the scene, only because she drove and turned back from when she drove to some distance on the same road, came back to where the decedent had lain. So it's not entirely clear as to whether that witness may have been referring to that testimony, notwithstanding. There is no reasonable inference from the testimony provided by the civilian witnesses that she fled just simply because the cruiser cam clearly shows that she did not flee from the scene. The car was parked. She drove a distance at the direction of the police officer by whatever means he indicated to her, and she did, and she came to a complete stop. There was no evidence that she had fled from the scene. The
Can I ask you a question about that? You briefly mentioned that it's your understanding that the video is submitted. We did issue an order that that we wanted the parties to work together to submit the video. Have you had a chance to look at it? Have you worked together on that?
We have, Your Honor. We
Okay.
filed a joint motion to the trial court, which was allowed, and we received notice, or I received notice certainly last week, that the Exhibits 7 and 27 have been transmitted by the clerk's office. I've not confirmed with the clerk's office.
Okay, we haven't got it. It's not on our docket yet, but it's coming.
I'm happy to follow up with that with the trial court, Your
Okay.
Honor, when I am able to. Notwithstanding, we addressed that as soon as I believe we got the notice from the appeals
Good,
court.
thank you.
So, moving along to the other part of the evidence that I think we can surmise that the judge may have been relying on by way of statement that she made to the police, which is an unequivocal denial after he inquired of her whether that she hit some person, and she said, "I did not hit anybody." Now, that statement alone, could it have warranted or supported the judge's instructions on consciousness of guilt? I suggest it does not.
Why?
I'm sorry?
Why?
An unequivocal, well, I understand we're talking sufficiency versus qualification, but an unequivocal denial would have been inadmissible notwithstanding, and can't be used for some other purpose here. On top of that, a denial, if it were allowed to come in for this purpose, would certainly eviscerate case law that says unequivocal denials are simply not admissible. So in this instance, that statement alone would not warrant a consciousness of guilt instruction. It was not intended to mislead. It was simply a statement, and it's certainly consistent with her state of mind and consistent with the defense of lack of criminal responsibility. So the fact that the judge gave this instruction mitigates, or eviscerates the defense's lack of criminal responsibility. It was not asked, no one asked for the instruction. Understand that defense did not object to the instruction, but jurors rely on judges, rightfully, as case law tells us. As an arbiter of the trial in the courtroom, the judge's instructions carry significant weight. The fact that these instructions at all were given guided the jury to assess this flimsy, I suggest, conduct that did not warrant the consciousness of guilt, and it helped them to evaluate evidence that may not have been appropriate for them to evaluate in assessing and deliberating the defendant's guilt, and minimizing the fact that the defense mounted a lack of criminal responsibility defense.
In terms of your challenge to the content of the instruction, my understanding is that you're arguing that the judge erred because he failed to explain what specific conduct was at issue with respect to consciousness of guilt. Is that correct?
Yes, Your Honor.
What authority supports your argument?
Your Honor, relying on the model jury instructions and relying on the fact that when the jury is instructed as to, you may consider certain conduct that came in through the trial, but without giving them specific instructions as to what that conduct is, how would they know other than they're left to conjecture?
Okay. What legal authority can you point to that supports your argument?
Your Honor, at the very moment, there's no case that comes into mind. If I cite to any in my brief, I would certainly defer to those cases. I'm happy to provide a post-16L letter if that is something that the court is inclined to have me do. But I think we have to go back to just the fundamentals of a jury needs to be guided in assessing and deliberating this evidence. A judge telling them...
Wouldn't you be worse off? Wouldn't your client be worse off if the judge said, well, you might have heard evidence, or this one witness said that as soon as the police came, he'd fled. You could consider that. I mean, wouldn't you rather keep it a little bit vague? He said, may have fled the scene. I mean, aren't you better off with that than the other way?
Not necessarily, Your Honor. I think that the jury should not be left to conjecture and to speculate as to what conduct
but if
the judge is
if the
referring
judge
to.
said, now you heard evidence that this particular witness said that he drove away, you would be here saying the judge put his finger on the scale and was telling the jury to consider that particular evidence.
I think may, in this particular instance, is probably insufficient, given the evidence as it came in. Only because Exhibit 7 is so unequivocally clear that Ms. MILESI's car was parked in the middle of the street, idle, not moving at all, and where the civilian witness testimony was not...
Does the cruiser camera, I gather that's what we're talking about,
Yes.
How long does it depict the car sitting in place there?
In the middle of the street, Exhibit 7, which shows the entirety of the cruiser camera from when the police officer came to the scene to when she stopped and where he removed her, is about 10 minutes long. When the cruiser approached the car, I think it was just a matter of seconds before she then moved. The car then moved to the side and came to a complete stop. So it was not very long at all, but
Is this the first cruiser or the second cruiser that subsequently stopped her over on East Hoosick Street or one of those side streets?
this is the first
Okay.
I want to make sure that I'm understanding the question. The cruiser camera that came...
There's two cruisers.
That's
In
correct.
one cruiser, the officer arrives at the scene, and I believe one of the officers stays there, and the other officer goes down the street and has a discussion with the defendant.
This is the first cruiser that came, that saw her car parked in the middle of the street and pulled over to the side of the street. I believe the second officer in that cruiser did not have a camera. I'm not entirely sure about that. Either that or it did not come into evidence, but there's only one cruiser camera. And they are both, I believe, Exhibit 7 and 27, which should be transmitted to the appeals court already.
Real quick, since we're running out of time, what relevance did the police investigation or lack thereof have to do with the defense of lack of criminal responsibility?
I'm sorry, Your Honor, can you repeat that
You say
question?
that the counsel is ineffective for not asking for a Bowdoin instruction. What does that have to do with, how would that have, did he make any argument about police investigation in the closing argument?
Yes, both parties did make...
What was that argument? How does that help your defense?
I think that is related to this first issue that we raised, which is that without guidance from the trial court to instruct the jury as to how they should evaluate
what is the
that.
evidence that would have referred to? So you can consider that the police did a bad investigation. How would that affect your criminal responsibility defense?
The instructions that the judge could have given regarding lack of a certain investigation, particularly a civilian witness who specifically told one or both the police officers that they saw everything as it unfolded, was just allowed to just leave the scene, and there was no other investigation. The instructions themselves would have allowed the jury to assess that in their deliberation and whether or not that impacts their ability to come to a verdict. I suggest
But
that...
I mean, there was no, at trial, your client was not contesting that she hit the victim, right?
That's correct. But she was also charged with leaving the scene. So if there was a witness there that the police could have conducted a follow-up investigation, somebody who specifically said, well, I saw everything, and then just was allowed to leave the scene, and they did not at all follow up, certainly not in the record if they did so, I think that that may have had an impact if the judge was able to instruct the jury as to how they could assess that.
Okay, and then how do you establish prejudice when the law is clear that the judge never has to give a Bowden instruction?
Your Honor, I understand that the Bowden instruction term itself is a little toxic. There is an omissions instruction which which takes from the principle of Bowden. So I understand that the trial court is not required to give such an instruction, but here, where the instruction is warranted, and this is in the context, incidentally, of ineffective assistance of counsel, where she diligently challenged the police investigation. This was only an end. This was a period to that sentence. So not requesting it is just illogical, makes no sense. It would
Yeah, right, that's on the first prong, but the second prong, if the judge, you have to show that it would have made a material, that it deprived your client of a material defense. And if it deprived your client of a chance that the judge may or may not have given it.
Well, Your Honor, I think the case law is quite favorable to the defense, which is if it is requested and where the evidence warrants it, if we're here to speculate, would the trial court have likely given the instruction? I suggest that the trial court
unlike
would have
Dargon
given
that we were
the
talking about in the last case where the SJC said judges should give it, here the SJC has unequivocally said judges don't have to give it.
No, but if the evidence warrants it in this case, and I suggest that it did, where the police officer let go of a recipient witness who specifically said that they were a witness to the entire incident, I think that the evidence was pretty strong to suggest that the instructions would have been given. If there are no other questions, I'll rest.
Thank you very much, counsel. We will hear from the Commonwealth.
Good morning, Your Honor. Stephen Greenbaum for the Commonwealth. The court will be able to look at this video and see what it portrays. But since counsel has given her interpretation, just quickly, what this video portrays is the cruiser coming up behind the defendant's car, which is parked in the road, and based upon the other testimony in the case, she's parked in the road at the time period when she's driven back and is trying to move the victim's body on the ground. She's parked there. When the cruiser comes up behind her, as the cruiser is pulling up behind her, the defendant, it's not clear whether she's outside the vehicle. She gets in the vehicle, she immediately starts up driving, and the cruiser is following. It's not like she pulls to the side of the road as she's driving. The cruiser follows her for several hundred yards with the flashers on until she pulls over. In other words, she left the scene and the cruiser pulled her over for a stop. I believe that's what you'll see on the video. Based upon my having seen the video, and I hadn't watched the video until I saw the panel said they were going to bring it in. On page 13 of my brief, and I perhaps confused you, Judge Neyman, by suggesting that the jury was looking at different cruisers. Once you see that video, what becomes clear is that Officer Baker's testimony, and the testimony that I think the defendant's relying on about the defendant's conduct after she stopped, begins at the point after this initial meeting where he comes up behind her, she drives off, he pulls her over, then they stop. Then they go into more taking testimony about that. But the first thing, the beginning thing that the prosecutor, the Commonwealth showed was that video of the beginning of that event.
So your sister's viewpoint that she is expressing is that the video contradicts the statement of the witness who said when the police arrived, the defendant left the scene. You seem to be arguing that the video is not inconsistent with the eyewitness testimony, but rather corroborates it.
Absolutely. It absolutely corroborates it.
We'll have to
You'll
look at the
even
video.
see as it stops, as the cruiser comes up and she takes off and the cruiser goes, you can see one of the witnesses testified, pointed, go get her. You'll see that person saying, go get her. And he takes off and goes after her. And as for the issue about I didn't hit anybody, the argument now about unequivocal denials was not made in the brief, and I didn't address it. And maybe that's a good argument, but the defendant didn't seek to exclude it. And in this brief is only arguing that it shouldn't have been, that it's not evidence of consciousness of guilt, which I think it obviously is. I think the court appears to understand the Commonwealth's argument. Consciousness of guilt is totally relevant to a criminal responsibility defense, and I agree with Justice Massing. It's hard for me to see how anything related to Bowden is relevant to a case where the sole defense was criminal responsibility here.
Well, Attorney Nocum, if I'm saying it right, said that it was contested on whether she left the scene, and there was a witness left unturned there. Wait, is that?
I don't recall that there was any argument that the defendant didn't leave the scene or didn't do or wasn't under the influence or any of that. The whole entire defense was criminal responsibility. Now, maybe I missed it, and again, I was focusing more on the homicide, but I don't think there was any case made that didn't happen. In fact, in the prosecutor's closing, and I assume the prosecutor wouldn't have gone out on a limb, that's volume 3, page 140, he describes, he describes that the video, and the first policeman showed up in his car. At that point, she got into her car and started driving away. I don't think that there was any dispute that the defendant fled the scene in this case. And if there are no other questions, I will rest on the brief.
Hearing done, thank you very much. The case is submitted.
Thank you
Thank
both.
you.
I'm going to call the third case, but I just want to tell anyone in the courtroom that we will take a brief mid-morning break after the third case. And the fourth case we'll hear after the break is the DCF case. So the next case is 2022 P990, Commonwealth versus Aquino.
Your Honors. For the record, my name is William Keefe.
Could you just tilt the mic up a little bit? It's directional. Yes, thank you.
So, Your Honor, this is a Padilla-related appeal. I think the district court judge erred in not finding that Mr. Aquino, and by the way, my client is in court, he's wearing a blue suit in the public gallery, but the lower court erred by not finding that the defendant had an otherwise available defense, and I think any fair assessment of the evidence is that, in fact, he did have a very triable case before him. Thus, but for...
Can I just stop you there on the first way of showing prejudice under the Clark case? There's mention in the evidence of the photograph of the victim's face with
Yes.
a apparently fairly prominent scratch on it. That photograph did not come in during the plea, and it was not offered and admitted during the evidentiary hearing, so it's not before us. Defense counsel mentions that this photograph was a real issue because it obviously could be interpreted as corroborating the account of the victim. Since it's not in evidence, and the burden was on the defendant to put it in evidence, don't we have to assume that it's really bad?
No, I don't think the court should assume it was really bad. The description of the photograph is referenced in the record. It is a single scratch on the face of the complaining witness victim. Notwithstanding that, there's a number of other parts of the state of the case against my client at trial. There is no third party. There's no third person present who witnessed the alleged assault.
But isn't that precisely why the photograph has an outsized role in this case?
I'd suggest otherwise, Your Honor. But in addition to there not being an independent, if there was an independent or third-party witness, maybe saw the alleged assault or maybe overheard a commotion, likewise, there's no 911 call. So there's no contemporaneous recording of, admissible recording of the complaining witness's claim that she was just assaulted.
So one of the things we know about it is that in Judge Rooney's findings, it says responding police officers observed a scratch on the victim's face, which was photographed. So what were they were responding to something.
Well, she's wrong. They didn't respond. This is another part of the state of the evidence. The victim did not call the police. She didn't call 911. The police never responded to the apartment. The judge was wrong.
Do you have the 911 call in front of us? I mean, you're telling me the judge, you're arguing the judge made a clear error here. Is there any, do you have anything in your brief or in the record that supports that the judge made clear error other than you're just telling me right now?
And if there was no 911 call, how were the police responding?
If there's no 911 call, what?
How were the police responding?
They didn't respond. The plaintiff, the victim drove to the Lawrence Police Station later on the same day, and it's on transcript 1, page 6, SRA 22. It's cited on page 10 of the Commonwealth's brief. That same day, the victim went to the Lawrence Police Station to make a report. So not only is there no 911 call, no other witness, the injury that we've talked about, I suggest is described in the record. It's not described as anything significant. The victim didn't go to the hospital or seek any medical attention. The claim of a scratch is actually inconsistent with her first complaint at the police station, which is that she was slapped a couple of times, not scratched. So,
but counsel is the one that focused on this as an obstacle in the case.
well, trial counsel, in talking to the appellant in lockup on the morning of the trial, was explaining to the defendant how a not guilty verdict was not a certainty, and that a guilty finding, a guilty verdict from a jury was clearly possible. And the way it would be possible would be with the victim's testimony, if believed, coupled with the photograph of the injury. But these domestic cases, you know, there are a certain number of them that are bad, very bad. There's a large number of them where the complaining victim witness doesn't want to cooperate with the prosecution of the case. And then there's a certain number of cases in the middle, which are jump balls. And these cases are inherently triable. It is, and as in this case, it is a he said, she said. I don't like that term, but that is actually what the state of the evidence is. The defendant, if he testified, would have said that they got into an argument, he didn't strike her, didn't hit her, he left, he rose an issue with her, which is this fake lease that she created in an effort to divert his rental income from his apartments, and he walked to the Lawrence courthouse with her following him in a car, pleading with him not to go to the court. And then lo and behold, sometime later in the day, she shows up at the Lawrence Police Station and makes this.
How do you address the indication in the record that the police overheard the recorded threat on her phone?
Yeah, so this is the second case. This is the restraining order that was dismissed. Docket.
Is there one restraining order case or two? Was there just one?
Just one restraining order charge. That's docket 18.
I believe there are two charges, one case, the second case.
Yes.
Two violations, one case?
Yes.
Okay.
Yeah. And it's referenced in the Commonwealth's brief on page 11 that I think a fair assessment of that evidence is that it doesn't exist. The police, the Commonwealth requested the victim to turn over the recording of the alleged threat, and according to what's referenced in the Commonwealth's brief at page 11, when the police attempted to obtain copies of those recordings, the victim stated that the messages are real bad, and there was no way she would give them to the police without a warrant. I mean, the cases presumably would have been tried together. That would have come out in front of the jury, and I think would have clearly impacted the credibility, lack of credibility of the victim in the case. So, if you look at that part of the prejudice prong under Clark, the defendant clearly had a triable case. I mentioned a jump ball, but we've got obviously a standard of proof and burden here of reasonable doubt. So these cases are inherently triable. So the defendant, I think, clearly has established that part of the prejudice.
Can I say, I want to say something and ask you something. First, I found the plea colloquy, and you're right, there was no 911 call. She came to the station, so you're right about that. So if your client had chosen to go to trial, and like I said, if he took the risk of going to trial based on this viable defense, what was the worst case scenario of a sentence if he had gone to trial? Which I want to compare that to the time served that he got.
Yeah, and the worst case scenario is 2.5 on. I don't know what the max is on a restraining order violation, but on the domestic assault and battery, it's 2.5. He has no record. This was literally his first offense. He had been locked up for 140 some odd days. I'd like to think that had he gone to trial, the judge would have given him a time served, probation, suspended type sentence. It's possible.
So
possible he could have gotten worse.
So there's really no risk of going to trial.
It's possible the judge could have given him 6, 9, 12 months. I doubt it would have been a maximum sentence. So the defendant was not going to be able to.
Okay. Can I ask about the special circumstances prong?
Yes.
The record shows that your client has a good job, owns property, has a good life in this country. Was there any showing of a danger he would face if he had to leave the country?
No, and the judge cited that, and respectfully, I'm arguing that the court gave very short shrift to each of these special circumstances and prejudice prongs that were presented to her. The Livarenko case, I think, is the only case that deals with refugees and those claiming persecution in their home country. Mr. Aquino is not alleging that. He's not claiming that, and I don't know if the court seemed to focus on that. It's not an element that he is required to prove unless he's claiming future or past persecution in his country of origin. But I was in the immigration court this morning filing something for my wife, who's an immigration attorney. It is a mob scene there. A lawful permanent resident who has a green card. That green card is gold, solid gold. He's been a LPR since the day he arrived here, sponsored by his mother. He is an industrious, hardworking young man. He has his mother here who lives with him. He's got siblings who also live in Massachusetts.
How do we deal with the fact that, at least in great part, the question of special circumstances and whether your client would have pled guilty anyway is a question of fact? And this is a case where the judge, and here the motion judge was the plea judge, made a determination of fact based at least in part on her assessment of credibility, and said, I think he would have pled guilty anyway. How can we overturn that?
Well, I think that adverse credibility determination of my client was based in large part on his perception that his lawyer was pressuring him or forcing him to plead guilty. And I don't think it's material to the assessment here, but I don't know that the district court judge could make a finding of fact that the defendant would not have gone to trial if he had been informed that he, by pleading guilty, is subject to mandatory removal, mandatory deportation. He would have, according to him, decided to roll the dice and see what happened at the trial. And that is where he presently is. He is facing mandatory removal as a result of this conviction because it's a crime of violence. It's a sentence of greater than a year. It's considered an aggravated felony by the immigration authorities. So he's gone once immigration gets their hands on him. But in addition to being a lawful permanent resident, he's been a member of Local 22 now for just over 10 years. His pension just vested. He was making almost $100,000 a year in 2018. He made $150 last year. He's making $44 an hour, $66 overtime pay. He purchased his first home in 2017. It's not just any home, it's a 3-decker. It generates rental income, it pays for itself. He obviously, this was not back at the time of the plea, but he's looking to purchase additional real estate. The script that was presented to the district court judge is that this defendant is and has embodied and experienced the American dream. He's the definition of an immigrant success story. And again, the short shrift that's given to these issues by the court in its decision, I think it's page 4 or 5, it's dealt with one sentence. One sentence.
Just one quick question. Do you agree that if your client had not accepted the plea deal, that he would not only have had to prevail on the domestic A and B case, but also would have needed to prevail on the restraining order violation as well in order to avoid the mandatory deportation or mandatory immigration consequences?
You know, I don't know the answer to that question, Your Honor. I don't know if the restraining order violation, it's not a crime of violence, because these crimes occurred less than 7 years from him gaining his permanent residence, I think it means that he's ineligible for cancellation of removal, and this is getting into the weeds on these immigration law cases, but I think that's his only avenue to avoid removal. So it could have had the effect of being mandatory deportation.
It's interesting that you say that because you and Attorney Gleason, between two of you, have 70 years of experience, and neither one of you, as you said during the motion for new trial hearing, neither one of you knew that there were mandatory deportation consequences here or mandatory immigration consequences in light of the plea. That makes it hard for me to understand how the first prong of Safarian is met, but I understand that's conceded here. It seems to be a strange standard.
Yeah. I like Justice Cordy's dissent in De Jesus, where he laments the fact that we're required to become experts in this field of law. Last thing on that restraining order case, it was likewise very, very triable. I read that provision of her refusing to turn over these supposed recordings of the defendant threatening her. So, yeah.
Thank you very much,
Thank you,
Counsel.
Your Honor.
We'll hear from the Commonwealth.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. If it's all right with your honors, I will start straight off with speaking to the strength of the defendant's case, or the lack of an available substantial defense if he'd chosen to go to jury trial. Although my brother has raised many pieces of evidence that were not a part of this case, that doesn't negate the fact that there was a photograph that plea counsel himself described as problematic to the defense. Of course, every case can be stronger with more evidence, but that doesn't mean that this case was not strong. And I have cited to an unpublished case, Rodriguez, where a similar amount of evidence was presented, and this court did find that case to be strong. As to the restraining order charge, I also respectfully disagree with my brother, where the police report says that the recordings from the victim's phone were not available. It was very important that a police officer potentially would have been able to testify to the existence of those recordings. I think that is indeed corroborative, and again, makes these cases very strong for the Commonwealth.
How would that have come in at trial, given the hearsay layers of a police officer testifying to what a phone recording from some unknown person might have said?
Your Honor, I would say that at the least, the officer would have been able to testify that she did hear a recording on the victim's phone. And perhaps she couldn't have testified to the actual contents of the recording, but it is persuasive that she would have been able to say, yes, I heard a recording, if the victim was also testifying to the existence and the contents of the recordings.
How does the Commonwealth interpret what the victim said about the unavailability of the recordings?
It's my understanding from the police report that obviously there was some reluctance to provide the recordings to the Commonwealth, and without, I suppose, getting into extra record issues, I think she could still testify to the recordings. It would have, of course, been stronger to have the recordings and to be able to admit them. There's no question of that. However, again, I don't believe that the case is not strong for the Commonwealth, given the fact that an officer did hear recordings on the victim's phone.
Please go ahead.
No, I was just going to say, my understanding is the message on the phone was not from the defendant. So that is...
It's my understanding that the recordings were from the defendant. However, the violations of the restraining order would have been through allegedly third-party contact. So I believe that the actual restraining order violations were made through allegedly another person trying to convince the victim to drop the case. So the recordings themselves might have been helpful to prove the case where the Commonwealth was trying to show that this was action that was at the direction of the defendant.
And I know the victim was available on the trial date, and the plea date. What do we know about the availability, if anything, of the third party?
I don't believe we know anything, Your Honor.
That's okay. So let's go back to Judge Milkey's question on special circumstances, because I think this is really where the rubber meets the road on this case. Justice Milkey asked Attorney Keefe whether and to what extent this determination involves findings of fact, whether it's an issue of fact, actually, as opposed to an issue of law. Can you address that?
So, I'm sorry, Your Honor, I'm just looking at my notes from that question. And I'm not sure if I'm going to answer Your Honor's question properly. I would just argue that in this instance, the judge heard significant testimony from the defendant and from plea counsel. She was the motion judge and the plea judge, and after having heard the testimony of the parties, she made fairly strong credibility determinations based on that testimony. And she found that the defendant was not credible where he was claiming that defense counsel...
She found Attorney Gleason credible. She found the defendant, at least in part, not credible.
Yes, Your Honor.
My question is, in light of those findings, can there still be special circumstances found?
So I would say that she did not find the defendant's testimony around his connection to the United States uncredible. So I would say, of course, there are things in this country that he has a connection to. It would be disingenuous for the Commonwealth to say that he has no connection to the United States. However, notwithstanding all of those factors, that does not end the inquiry. The judge is not required to only consider the facts that the defendant has presented. And this is where I also disagree with my brother, that she was allowed to consider what might happen to the defendant if he were deported. That was fully within her purview. It was important in this case because, of course, he has connections here, and there are circumstances which may be important to him, but that does not rise, in the Commonwealth's opinion, to special circumstances. And the judge was not abusing her discretion when she found this.
But in terms of the test here, under prong 2, what the defendant is required to show is and I'm quoting, a reasonable probability that but for counsel's errors, he would not have pleaded guilty. So he does not have to show that he would not have pleaded guilty. He has to show only a reasonable probability. What does that mean? Is that analogous, for example, to probable cause?
Well, Your Honor, it's first my understanding that in order to get to that determination, the defendant would have had to have made a sufficient showing under any one of the 3 Clark factors.
No, but there were, be they on the exceptional circumstance, special circumstances. Putting that term of art aside, there are some very strong reasons here why he would want to stay in this country. An unusual confluence of circumstances. The performance standard is still, as I read the cases, whether there was a reasonable probability, but for counsel's errors, he would have not have pleaded guilty. What does the reasonable probability mean?
Your Honor, it is...
The chance?
Well, I do believe, and I can't recall exactly the case, but I do believe that part of that determination is the defendant making at least a showing that he would not have pled guilty and he would have gone to trial but for...
By what standard? He has to show...
That he has to claim...
By a preponderance that he would not have pled guilty? Or is there... Does reasonable probability mean something else?
I'm not certain, Your Honor, and I'd be happy to write a 16L letter to clarify that.
That would not be a 16L letter.
Oh,
but if
I apologize.
If we would,
It's defined in Strickland. it comes from the ineffective, it comes from the Strickland standard. It's that undermines our confidence in the result. It's less than probable cause. But the judge, in terms of that, all she finds, I do not find there are special circumstances. At the time of the plea, he'd been in the United States for 9 years, gainfully employed, earning a significant salary. So those are all things in favor of him. I mean, that in favor of special circumstances. His affidavit states his immediate family is living in Lawrence. Okay, that's still in his favor. The only thing against him, there is no information provided with respect to any remaining family in the Dominican Republic or whether he would suffer significant consequences. And Attorney Keefe said that's sort of reserved for, when somebody's being persecuted in their home country. Is that?
And I disagree with that assessment, Your Honor. I would argue that Lavranenko and Lease both list many factors and also state that the list of factors is non-exhaustive. The judges allowed and should consider each case on a case-by-case basis. And I would also argue that in a number of cases that I cited in my brief, and also cases that the defense has cited, there were other factors in addition to, I suppose, or not in addition to the factors. The defendants had certain other factors which made it so that it was important for them to remain in the United States. One of those things was age at arrival in the United States. And I would argue that I've cited at least 5 cases where the defendant was quite young and would have attended school in the United States, never had an adult life outside of the United States, and in at least one case didn't speak the language of his home country. So even though this defendant has a job in this country, because he came to the United States at 22 or 23, he presumably would have lived the life of a young adult back in his native country. So while he, of course, has reasons to want to remain in the United States.
Can you say the judge focused on the fact that he had spent a majority of his life in the DR. Another way of characterizing the same facts are he spent almost all of his adult life in the United States. Two-thirds.
I suppose half glass full or half glass empty. I mean, it was clear that he had been in this country for a number of years. But I think that what differentiates this case from the other cases that I cited in my brief is the fact that there aren't special circumstances. I would argue that is because this defendant, although he has a connection to the United States, he does not have certain other factors going in his favor that were present in these other cases and which I would argue require consideration. And again, that goes to age at arrival, whether or not the defendant has attended schools in this country, whether or not the defendant requires support from family or government, and what kind of life.
How does the school bear on this? Given, I mean, he was here for almost a decade at the time of the plea, had a high-paying job, owned a home, his family was here, etc.
And no question, again, that those factors exist. But I, again, would just argue that his age at arrival and having attended schools not in this country, I suppose, goes to his overall connection to the Dominican Republic versus the United States. It's not that this isn't a person who has limited memory of life in the Dominican Republic. If he came to this country at the age of 22 or 23, again, presumably he would have had friendships, some sort of family, jobs. It puts him on different footing than defendants in other cases. And I would just argue that those factors that he did not admit into evidence, did not discuss what may or may not happen to him upon arrival in the Dominican Republic, that doesn't mean that's off the table. And actually, I would state that he did bring that into question in his testimony when he was asked, why do you want to stay in this country? And he responded, for security and everything. So what sort of security is he seeking? I think the judge, having heard his reason for wanting to remain.
How about job security?
Yes, but I think that doesn't take away the fact that security, that what would happen to a person if they were deported, what sort of life they would leave if they were deported, is a significant part of the consideration here.
If the judge had allowed the motion to withdraw the plea, would that, the defendant would presumably be retried, or tried rather, for the first time on the A and B. Would he also be tried on the restraining order case because that was part of the deal and it was dismissed? Does that resurrect the restraining order case?
I would argue that he could be tried on all of the
all
charges
of
that
them?
were against him.
Okay. All set.
I'll rest on my brief.
Thank you both very much.
Thank you.
Well argued.
Interesting matter. The case is submitted. We will now take a break. We should be back here at about 11:25.
Court, all rise. Court stands at a brief recess.
should be coming on in about 4 minutes or so. It should be coming on in about 4 minutes or so.
Court is open. Please be seated.
We are back on the record with our fourth case of the morning. It is a DCF case, 2023 P858, and you all are old hands. You know not to refer to the names of the parties, and please refer to them by their status. Counsel.
May it please the court. My name is John Dennis, and I'm representing the appellant father in this case. I'll be brief. There's really one issue here, which is the issue of visitation with his son, who's now about 6.5, I believe. And if I can kind of get to the issue, father stipulated to termination, but reserved the right to be heard with respect to visitation, and that's what was tried. And the circumstances of this case include, ordinarily, I think bonding is considered under the case law to be a pretty significant factor, but due to COVID and the visits that the father had with the kid beginning March 20, really affected his ability to have a bond with his son, because the Zoom meetings were really difficult for everybody. And then following that, he had other issues. But what I want to focus on is what's unusual here. The case law adoption of RICO tells us that bonding isn't the only consideration. In fact, it may not even be the most important consideration with respect to ordering visitation with a child. The standard is what's in the best interest of the child. And I think there's some unusual circumstances in this case as to what that means, because this father and this child's mother are together in New Hampshire, and they have custody of the child's younger sister and continue to have custody. The mother...
Tell me if I'm wrong, counsel, but the judge didn't prohibit visitation, correct?
He did not order visitation, that's correct.
So...
The reason is, well, mother was the beneficiary of an open adoption agreement which the department and the pre-adoptive family agreed to. 3 visits a year, but would not agree to the same terms with father.
They left it to the discretion of the legal custodian, correct?
And correct, and given the fact that they would not agree to father's visitation when mother and his daughter were visiting, I think that is a pretty good indication that they would be resistant to anything but an order of visitation for father to participate in these visits.
So when I read your brief and when I hear your presentation here, what it sounds to me like is, well, this kind of isn't fair to the father. He didn't have a chance to bond. He has to sit in the car. But is there any evidence that it would be good for the son?
Yes, and that's what I was focusing the court's attention to, the language in adoption of RICO.
Focus my attention on the evidence that it would be good for the son.
Well, I think that for the son knows he has a biological family and a sister that live together in an intact household in New Hampshire, and he's not living with them. He obviously, given the fact that there would be visits being conducted with his mother and his sister, and frankly, father has to drive them to the visits and would literally be sitting outside somewhere while they're visiting, that would have an adverse impact on the son. The son's own, just imagine, your identity is tied to your relationship with your biological family. And I would think you want to have, I think it's in the son's best interest to believe that his parents love him and want to include him equally, and as well as his sister, and that he's not going to be, that there's something wrong with him because father's not being allowed to visit with his sister and his mother, even though they're living together. That would, to me, on its face, present the kid with some cognitive dissonance that might be hard for him in his own self-image. To put this kid in a situation where he doesn't know what to think about his own family. It's confusing, and I think it's difficult for the child. That's my argument. And I think
But isn't that an argument you can make, or your client can make one way or another, to the adoptive parents?
Oh, well,
the issue is who should decide what's in the best interest of the child going forward.
Well, I think trial court, in the first instance, when the issue is raised, Alona tells us it's a two-step process. One, is it in the best interest of the child? And two, do we have to order it because there's some resistance to that visitation by the pre-adoptive family, such that in order to protect the child's best interest, an order would have to be entered. So that's the second prong, and I'm arguing that that's what applies here.
Can I press you a little bit on the argument that they have an intact family in New Hampshire? On the day of the trial here, it says that she has no car, no transportation. There's a restraining order between the parties. That doesn't sound that intact.
It's no longer in effect. It was, obviously, if you look at the record, I believe mother punched father in the face while she was pregnant with this child. So
father had the restraining order, his father against mother?
No, I don't believe he did.
Okay.
But, it's
a tough situation.
Given the fact that at least New Hampshire's Department of Youth Services feels these parents are adequately parenting this child's younger sister, and there's been no issues. So, as I said, I'd be brief. If there's any more questions, I'd be happy to answer them.
Hearing none, thank you very much.
Thank you, Your Honor.
And I understand the appellees are splitting their time 8 and 7.
May it please the court, my name is Carol Frizzoli, and I represent the Department of Children and Families in this case. The trial court properly found that the post-termination and post-adoption contact was not in the best interest of the child, given the overwhelming, undisputed evidence that, 1, the child and father do not have a substantial relationship as evidenced by the child's complete withdrawal from father at visits. 2, the child has requested that visits with father be cut short and has often not engaged with father during visits. And 3, the father has acknowledged his anger issues, threatening social workers and storming out of visits, yelling profanities. Father has not seen this child since November 23, 2021, despite the department offering visits with the father, and father has not made any effort to have continued contact with his son or remain involved in his son's life. Father has not done any services to address his shortcomings during this care and protection case and has continued to demonstrate an inability to manage his emotions, which was evident during the 2-day hearing. After father stipulated to his termination, the trial court gave him the opportunity, a 2-day hearing, to present his case on why it would be in the best interest of this child, because that's the focus, to have post-termination visitation and not leave it to the discretion of the pre-adoptive family. And I also wanted to point out, when the pre-adoptive family and the mother entered into the open adoption agreement, as testified to by the social worker, there was knowledge of a restraining order between the parents. In fact, the visits prior to November had been separated because the mother had disclosed domestic violence between the two, where the mother was having the first hour visit and the father would have the second hour visit. During those second hour visits, that's when the child very often did not want to ask the father to cut the visits short, did not want to continue with the visits with father, and very often due to the father's behaviors during these visits. So there was, at the time that open adoption agreement was entered into with mother, there was what, to everyone's acknowledgement, was a restraining order between the two. The social worker testified she learned the first time that...
Could you remind me of the timing when the open adoption agreement was entered into and the trial?
From my understanding, the open adoption agreement was agreed to back in December of 2021. The trial was not till June. It was never finalized according to the social worker's testimony at trial. There were issues about the whereabouts of mom, her location, and the social worker at the time of trial in June of 2022 had still not obtained the signatures of the mother on that open adoption agreement. But the social worker did further testify at trial that up until the day of trial, she believed the restraining order was in existence, and it was on that day of trial that she learned that where father said that him and mother were back together.
At what point did father signal his willingness to stipulate to unfitness and termination?
Again, in June of 2022, when he entered into that stipulation.
So, and it's fair to say that counsel's representation was accurate, that father was not offered an open adoption agreement?
Correct. Father was not offered an open adoption agreement, and that was based on the department, primarily based their recommendation based on the child's reactions to father at the visits. And the social worker testified to that at that 2-day hearing on the post-termination visitation.
My recollection is that the visits did go well in some respects. Is that at least some of the visits?
There were, the difference is the pre-COVID visits, there was testimony that those visits went relatively well, and then COVID hit, and the Zoom visits did not go well at all. Father could be heard in the background screaming, profanities, and then when they resumed the in-person visits, no, the majority of those visits did not go well at all. The child shied away, clung to the social worker during those visits, asked that the visits be stopped, wanted to go home. It was quiet. The only time there was some testimony that the only time that, and there was also COVID protocols in place where, parents were not supposed to be lifting the children and, wearing their face masks, which father refused to do or refused to wear it properly. And then in one visit, he tried to engage the child. I think there's testimony that, he picked the child up, even though he was not, again, it was against the COVID protocols that we were having during visits, and tickled them and said the child was more engaging. That's the only positive testimony about the father's visits with the child. So again,
when in the time frame was that particular one?
That particular one, I believe that would have been in August of 2021.
So a couple of months before they stopped.
Right. And that was because at that point, that's when the visits started being separated. At those visits, there were father and mother together, and then mother in October of that year disclosed some domestic violence, and the department, whenever that is disclosed, will separate the visits, is what happened in this case. So again, it is the department's position. The standard here is abuse of discretion. Did the trial court, after this 2-day hearing, abuse its discretion in not issuing an order for post-termination, post-adoption visitation? It's the department's position that the judge did not abuse its discretion after taking 2 days of testimony, witnessing the father's behavior during this 2 days where he was had to be instructed to not blurt out, did not comply with the court order of being on video. So again, it was 2 days of testimony, and after that, the judge came to the conclusion that he would leave it. It was in the best interest of the child that leave it to the pre-adoptive parents. So without any more questions, I would rest on my brief.
Thank you very much. We'll hear from counsel for the child.
Thank you.
Good morning. May it please the court. My name is Alan Campbell, and it's my privilege to represent the subject child in this case. The subject child asks this court to affirm the judgment. There was no abuse of discretion in declining to order post-termination or post-adoption visitation for father, primarily because there was no bond between them, but also because the visits didn't go well and child doesn't want visits. And as we know, under the abuse of discretion standard, the question is whether there were any errors of law or whether the decision falls outside the range of reasonable alternatives. And the child suggests that there were no errors of law, and the decision is perfectly reasonable. It falls squarely within the realm of reasonable options. In fact, had he ruled otherwise, I would be here making, I believe, a very strong argument that it was an abuse of discretion to order the visits. Actually, most of what I've said was already mentioned by counsel for DCF. There has been some mention about Ilona and whether or not the pre-adoptive parents would allow visits. Under Ilona, you only get to the second prong if on the first prong you find that visits are in the best interests of the children. Then you decide whether or not an order is necessary to protect those rights. Applying Ilona to this case, in the first instance, the judge didn't find that visits were in the child's best interest. So you don't reach the second prong. And as to concerns that the child may at some point in the future want to have visits, he has visits with his mother. They know who father is. If he wants to have visits, he can address his At that point, it'll be his parents, and they could reach out to father, either directly or through mother, if they're still together.
Well, what do we know on this record about the openness of the soon-to-be adoptive parents to rethinking whether visitation or some contact with their birth father might make sense?
Well, we know from this record that they were not open to an open adoption at this time. However, since they're the pre-adoptive parents, they'll presumably become the parents. Inherent is that these individuals will be able to look out for the child's best interests and to make decisions that are in the child's best interest going down the road. So I think we would have to assume that they would, if they believed at a later time that the visits were in the child's best interest, that they would act on that. Nothing else. I will rest on the brief.
Thank you very much, counsel. Thank you all very much. The case is submitted. Our next case, the last one of the morning, next to last one of the session, is Hutton v. Nantucket Board of Health, 2023 P 612.
Thank you, Your Honors. My name is Thomas Hutton. My wife Susan and I are the appellants in this case, challenging a decision by...
May I ask impertinently, are you in fact a lawyer?
I am a lawyer admitted in D.C.
Yes, thank you.
This case is an unusual case because it presents two instances of ultra-virus conduct by the Nantucket Board of Health. The first one is in 2015 when the Board of Health adopted Regulation 49. The Board of Health followed some of its required statutory process when it adopted Regulation 49, but it omitted one key element, and that is that it did not send a copy of the attested Article 49 to the Massachusetts Department of Environmental Protection.
I'm sorry, what is your evidence that they did not comply with that requirement? I understand that the DEP does not have a copy.
Yes.
Do you have any evidence beyond that?
No, but we've cited a Supreme Court case that says that under presumption of administrative, I forget the exact term.
Regularity?
Regularity. The record keeping of the MDEP and the search response provided to us by the MDEP are considered binding unless there is a strong evidentiary showing to the contrary.
But a central assumption of your argument is that this is a precondition to the regulation's effectiveness. What is your support for that proposition?
We've cited an array of ultra-vires precedents, including SJC cases, indicating that the regulatory body has to comply with its enabling statute. And in response, the Board of Health has not cited a single case contrary to what we cited. They've not distinguished any of the cases we've cited. And what about partial performance, partial compliance with the statute? Have they cited any cases saying that partial compliance is okay? No, they have not.
Well, but the issue isn't did they comply with the statute, it's are the requirements you're focused on preconditions to the effectiveness of the regulation? I mean, if the statute had said, and the town shall mail it in a blue envelope, and they didn't use a blue envelope, you wouldn't be arguing, oh, that makes the whole regulation invalid. Clearly, the legislature wanted DEP to keep a central registry of regulations, but that doesn't necessarily invalidate the regulation if they did not comply with it. At least I'm not seeing what the connection necessarily is.
I think the case law we've cited is on point, that when you adopt a regulation, you have to follow the enabling statute, and you don't have the authority to just wing it and say, oh, we're not going to fully comply with the statute.
No, but why can't you view it as they followed the statute in adopting the regulation? What they failed to do is, after they adopted the regulation, send it to the central registry at DEP.
Well, then the public lacks the notice that the legislature intended to provide.
But I don't think you're making any notice in fact argument here, correct?
I'm not making a notice in fact argument, but then there's no precedent, I think, saying no harm, no foul.
I'm sorry, did you have another question?
Well, no, I mean, I think this is an interesting issue, but to me, the meat and potatoes of this case is on the arbitrary and capricious standard. I would like to hear you on that, unless my colleagues have questions on the other.
Well,
Can I get there first? Yeah. And because this relates to the notice as well. So you're told you have to comply with Regulation 51, right?
Yes.
And then, but later you're told, or later you learn or something, that you're in the tight tank district across the bridge, so actually you have to comply with 49, right?
Yes.
And so there's no claim about like unfair surprise with respect to that. You eventually file an application for a variance from 49, right?
No.
Okay, so explain.
No, we did not seek a variance from Regulation 49. We did not need a variance from Regulation 49. The language of Regulation 49 does not require everyone to have a tight tank in the tight tank district. It's worded as...
But just before we get this, so I see the argument you're making, that you're talking about the wording of the statute, but there's no claim that you didn't understand that you were operating under Regulation 49. You understood that you had to. I mean, your argument is that we did comply with 49. That you can't. It's not a 100% thing. There's flexibility. So our experts filed a thing. We have, we're underneath the 51 regulation for nitrogen, but but you understand that what your filing was saying we're okay under 49. Right? Like, yes. You're not saying we have 49. We never heard of that.
We did not think that 49 applied necessarily because our engineer didn't think it was an impediment, but we were aware of 49.
Okay.
And we thought it was not an impediment because of the way it's worded. It's worded as a case-by-case sort of standard that a tank may be required as a, quote, last resort alternative, which was not in our case, and that the Board of Health reserves the right to require a tight tank rather than an IA system. And so our engineer read Regulation 49 and told us, you comply with it, and you also comply with Regulation 51, so you should be fine. And we were all surprised to learn that the Board of Health was treating Regulation 49 as a mandatory tight tank standard for all properties in the tight tank district.
So, otherwise said, I'm going to rephrase your argument. It reminds me of that line from The Verdict where Paul Newman says, if you're going to try my case, try not to lose it for me, so you don't have to agree with what I'm saying. But my understanding of your argument is essentially this. The regulation uses the word may, not shall. Under the regulation, it requires the Board of Health to make a discretionary call. However, the board has essentially adopted a mandate that tight tanks in this district must be used. Therefore, since they don't exercise discretion in any of these cases, that is either or both a due process violation, and it's also an arbitrary and capricious application of the regulation. Is that correct?
It's correct up to one point. You missed the third point, which is it's also an ultra-virus amendment to Regulation 49 as adopted, because Regulation 49...
Changing shall to may.
Yeah, exactly.
Changing may to shall.
Exactly. And so, and we've shown in our brief, that that change was adopted in an unrelated 2017...
And during the hearing, the board members said, hey, Pat, in 2017, didn't we decide that we were going to mandate these in every case? And they said, yep, so that's what we do, so you lose, right?
Exactly.
So,
And that's ultra-virus.
it's an interesting argument. What is your best legal authority for the proposition, before we get to ultra-virus, that that is an arbitrary and capricious application of the regulation?
Let me put it this way. When you go from a written regulation that says one thing to an unwritten amendment that is contrary to what is written, you're really talking about something that exists only in the minds of the Board of Health. It's like their imaginary friend. The mandatory tight tank standard only exists in their brain. And so that is arbitrary and capricious.
So if, under your theory, the board had to apply a case-by-case evaluation of whether or not there was a different feasible alternative, what's the standard that you think the Board of Health should have applied?
Standard should have been to treat us consistently with other IA application cases where the property size is sufficient to allow an IA system. And what they did is they put us into variance territory, saying you can't get...
No, I understand that, but let's say, okay, you win this, it goes back to the Board of Health, and they have to look at question X. What is X?
X is, do we comply with Regulation 51 and Regulation 49?
So what about the language in Regulation 49 that says, the Board of Health reserves the right to require any property owner with a failed septic system in this identified area to apply to the BOH for a tight tank in lieu of a conventional or IA on-site system? What's the meaning of that language?
You tell me. There's no standard.
Well, we will at some point, I promise you, but it would be helpful if you could help us out.
There's no enunciated standard. There's no known standard. It's just we reserve the right. If you're a tall person, well, maybe we don't like tall people, so that's no good.
I love tall people.
Well, I mean,
I love tall people.
Yeah. we see variations of this language all the time in statutes and regulations. Typically, it'll say something to the effect of, notwithstanding the foregoing, the Board of Health reserves the right to require X. That's not uncommon language.
But there has to be some standard known by which they make those determinations.
And that's your vagueness argument.
Excuse me?
That's your vagueness argument. You also argue void for vagueness. That's your vagueness argument.
Exactly.
There's no standard.
Yes. I'm arguing it's a violation of a due process based on void for vagueness.
Can I just make sure I understand the context of all this, the larger context? Because my understanding, and please correct me if I'm wrong, is that this whole matter started in the enforcement context where your current system was deemed in technical noncompliance because of apparently the separation between the leaching field and the groundwater. And that's what started all this, that there was then an order to fix the problem. This isn't a case that's driven by construction plans that you had. It's driven by your effort to comply with the enforcement case. Is that?
I think it's an exaggeration to call this an enforcement case. They sent a mass mailing out to all the property owners in the Nantucket Harbor Watershed District that had some type of failure of their septic system. And they said, you ought to comply with Regulation 51 by putting in an IA system that complies with Title V. And so right after we got that letter, we did submit such an application.
Okay, but it's accurate to say that there are no current plans on the table to expand the home, or I understand you don't want the restriction that goes with a tight tank, but that's different from saying you are currently submitting an application to expand the home.
No, we're not currently, but we're effectively precluded from doing that.
No, I understand that.
But, well, I'm not sure you understand completely, because we can't even get a building permit unless we get the septic system upgraded. So it's pointless to even plan anything until we get the upgrade approved. And enforcement, again, that suggests they were taking some type of action against us or against other people who got the same letter. They have not taken action against anyone who got those letters.
No, I'm not saying they were trying to fine you. They were trying to do a mass effort to bring a number of systems into compliance.
Yes, yes.
When you were asked by Justice Milkey about what could the standard be, you suggest that it would be Regulation 51 and compare your property to properties of a similar size. And I take it the properties of the similar size are mostly on the other on the other side of the bridge, not in the so-called tight tank district, right?
Yes. In the minutes where Regulation 49 was adopted, the then director of the Board of Health indicated that he thought that about 90% of the properties on our part of the island in the tight tank district would require a tight tank, which suggests that 10% would be available for an IA system. And I think that's a reasonable estimate, that we would be within the small percentage of larger properties in the tight tank district that could have an IA system, just like the Board of Health allows on the other side of the bridge.
But is it arbitrary to say, based on the science, based on what we know, that you would actually treat similar sized properties on different sides of the bridge differently?
I think that's arbitrary, yes.
So that
we've shown, number one, the water quality in our part of the island is better than the water quality in the part of the same watershed district where they give IA permits out like Tic Tacs. So, yes, I think it's arbitrary.
Okay.
I just have one more question. That is, when you say that the regulation is ultra vires or vires, what statute or provision is it violating? I did read your reply brief. I read the argument. I'm just curious.
Yeah. It's which statute is it violating? It's violating the statute that says number one, the 2017 de facto amendment to Regulation 49 should have been adopted pursuant to a meeting under state law, and we cited the state law.
I see.
Okay. And then been published, et cetera.
So that's a procedural argument.
Yes.
Got it. Okay.
You can sum it up in one sentence, and then we need to move on.
Okay. Again, my view is that the position taken here is that they're relying primarily on an imaginary friend, which is a mandatory tight tank standard that was never adopted pursuant to state law. Thank you very much.
Thank you very much, Counsel. We'll hear from the town.
Good afternoon now, Your Honors, members of the panel, and may it please the Court. Roger Smerridge of KP Law, appearing on behalf of the appellees, Town of Nantucket Board of Health and its members. The trial court's entry of judgment on the pleadings for the board was proper and should be affirmed. The case involves the board's interpretation and application of its own regulation promulgated to address a local environmental issue.
It may be the board's own regulation, but it exists in a larger regulatory framework.
Within the Title V context,
yeah,
yes.
And under Title V, there's a regulation that prohibits tight tanks unless there's no other feasible alternative to upgrading the system. Doesn't the Nantucket regulation have to be interpreted in light of that prohibition on tight tanks, such that if there is a reasonable alternative, the town has to allow it?
I think under the circumstances, and this is spelled out in the prefatory language in the regulation, that this regulation was adopted in conjunction with the DEP and their analysis of this tight tank district, this special area on the other side of the bridge, so-called, and the nitrogen loading issues in that area. And given that special environmental concern, the DEP had agreed that the the seasonal use exemption in Title V, in the regulations, would apply to this specific district so long as the town adopted the policy and applied the policy consistently, which is what it has done. Moreover,
I think you misspoke, actually. They waived the seasonal, right?
Well, it's an exemption. If you are seasonal use, then you can get the tight tank if it's...
Right.
In that email, which is in the record before the board, they said, we will consider that to be applicable here rather than the
We'll even let you have tight tanks if it's year-round and not just... Usually you can only have... But we'll let you have tight tanks seasonally. But the regulation that DEP approved didn't say it's going to be mandatory tight tanks. It said we may require a tight tank.
Yeah, it said we may require. It may be required, and it labeled tight tank as a requirement.
Right. But so the and in light of Title V, DEP approved a regulation that said, when there are proper circumstances, if there's no reasonable alternative, it's going to be a tight tank. But doesn't that leave open that there could be that the Board of Health is open to reasonable alternatives, and that's what DEP approved. The DEP did not approve a regulation that said we are requiring 100% tight tanks in this area.
No, but what the DEP also didn't approve is a regulation, a local regulation that says that a tight tank may be utilized, if certain conditions are met or things like that. It said that the Board of Health, the local Board of Health, which has the substantive knowledge over the local conditions, may require it in every circumstance, and that's how it's been applied.
In every circumstance?
In every circumstance, since it was...
Where is the in every circumstance language?
In the regulation.
In the regulation? Well, I think when you say something may be required, that is implicit, and that is how it's been read and applied.
Do you agree that the language may be required contemplates a discretionary evaluation?
I think in application it could, but in application here it hasn't. It has been required in every circumstance.
So I guess that begs this question. May, to me, seems to contemplate some form of discretion. You're allowed to do that, you're authorized to do that, but you've made it a mandate, or the BOH has made it a mandate. There is no exercise of discretion here.
No, and I don't think there is any question that there was exercise of discretion. The board was clear that except for the one case in 2017, which involved a IA application that had been in the pipeline before Regulation 49 was promulgated, they have required tight tank in the district.
We're exercising our discretion to mandate tight tanks in the Nantucket district.
Yes, essentially. And this goes to the reserve the right language that you alluded to earlier, Justice Neyman. In the discretion, I know this question came up, what is the standard? How is that applied if it is discretion as opposed to mandate? Well, it's the first three paragraphs of the regulation, which talk about the nitrogen loading and the environmental concerns. That is what they use as the guideline, and in the district, they have found, given the nitrogen concerns, every case requires a tight tank.
Well, say you have a 10-acre parcel in this, I don't think it exists, but say you have a 10-acre parcel with 20 feet of sand. Mount Nantucket happens to be right there. Property owner wants to install state-of-the-art septic system with nitrogen denitrification, and it's, you can drink the water as it's coming out the leaching field. Tight tank required?
Your Honor, in that case, it's possible that it would not be required.
How can that be if you're saying
because
regulation says
this is where it gets
automatic.
into the arbitrary and capricious nature of the application, because here there was record evidence that this IA system would not get to the same result as a tight tank. There was evidence in the record that there would still be 14 units. I can't remember what the precise scientific unit is. I'm not a scientist, but there would still be 14 units of nitrogen.
No release of nitrogen versus some release of nitrogen.
Exactly. And that alone, given the substantial deference that is afforded to the local board in this circumstance, that is sufficient to survive a challenge based on arbitrary and capricious nature, which is the cornerstone of a certiorari review. No court can substitute its judgment for that of the local board when applying these local concerns in a certiorari review, whether it's the trial court or this court or the SJC for that matter. Getting to the issue of the promulgation of the regulation, because I did want to touch on that. I'll happily come back to the certiorari issues because I know there are a couple. But a couple key points on the promulgation of the regulation. First of all, the standing issue. Now, I know on reply, the appellants say we didn't raise that in the lower court. There was standing issues presented to the trial court, maybe not in this percent interest, but standing is a subject matter jurisdiction question. It can be raised at any time up and through a final
At least there are cases that say that.
I'm sorry, Your Honor. Very well. Second, and this is even more important, nothing in Chapter 111, Section 31's last paragraph says that a local regulation, a local Title V regulation is somehow invalid if you don't follow the precise steps for getting it into the central registry. There's no statutory basis for concluding that a regulation, a local regulation would be ultra-virus or somehow totally wiped off the authority simply because it doesn't end up in the central registry. And particularly here, where Mass DEP did approve Regulation 49, did send it to the central office, and it was adopted. Otherwise,
I know they sent it to Lakeville. What's the evidence in the record that they sent it to Boston?
in the local DEP office letter of approval of the overall comprehensive water management plan, which incorporated Regulation 49, on the second page, there's the list of CCs, and one of those carbon copies is to Mass DEP Boston office.
Do you have a record citation for that?
Yes. It is Volume 1, pages 297 and 298. So it would be there. Actually, it might be 296 is where the CC line is, but it's somewhere in that 295 to 298 range of Volume 1. The third thing is, none of the cases that the Huttons cited in their brief, I think it's pages 26 to 27 that they point out in their reply regarding the ultra-virus argument, none of those cases support the argument. They all deal with the authority of the regulatory agency under its enabling statute to issue the regulation or the regulatory action in question. Here, there is no dispute that Chapter 111, Section 31 authorizes the Board of Health to issue a local, more restrictive regulation under Title V. So all those cases I suggest are in opposite.
Now, can I just stop you? In terms of DEP approval, they didn't approve this regulation in a formal sense, correct? They approved a plan. They asked the town for its comprehensive water management plan. The town presented it. The regulation was a piece of that, and they signed off on the plan. But they didn't, there's no review process for this regulation now passes muster, correct?
Not separate and aside from the water management plan, no. But as part of that water management plan review and approval process, the tight tank, it's Regulation 49, you'll see on the header, it's called the tight tank policy. And in the approval letter, it reflects that that policy is being approved as part of the overall management plan. But no, there's no separate.
If DEP, seeing that regulation, interpreted it as discretionary, then we could not read anything in terms of figuring out its relationship to the Title V regulation that prohibits tight tanks except in limited circumstances.
Well, I think that's where the email from DEP confirming that the tight tank policy can be applied universally if the town and the board adhere to it is a critical piece of the information that was in front of the board and directed and governed its application of Regulation 49.
I just want to ask, because Mr. Hutton does not get another chance to talk, is that email and the letter, the March 30th letter from DEP, Are those contested, whether we're allowed to look at them?
Not
It's
to my
not, they're not
knowledge.
subject to a motion to strike?
They are part of the administrative record that was before the Board of Health and therefore are properly before the court on a cert review.
It's the Santa Maria affidavit that's
It's separate from the Santa Maria affidavit, yes, Your Honor. I believe the DEP email may be at page 1, it's either 190 or 290, I think, of volume 1. I don't have it right at my fingertips, but it's in there in volume 1 as part of the record of proceedings. Turning back to the issue of the judgment on the pleadings and the certiorari review, again, there's no evidence, or I should say, the Huttons did not satisfy the burden of providing evidence that the local board's decision was arbitrary or capricious. And coming back to the question of whether this was a variance request, their own engineer in the letter submitting the packet, the application, whatever you may call it, to the board, described it as a variance request. Now, I know on reply, the Huttons say, well, that was with respect to Regulation 51. But if you look at that letter, it clearly references Regulation 49 as well as Regulation 51.
Isn't that a question of law, how it should be treated?
No, I don't think so. I think that's a question ultimately, again, for the Board of Health, and under a certiorari review, whether their decision on how to treat the application is part and parcel of the question of whether it was arbitrary and capricious. And here, they had language from the Hutton's own engineer saying, we're requesting a variance. Now, the critical...
But during the hearing on this, the hearing before the Board of Health, didn't Mr. Hutton's representatives make the very argument that this was not a variance request?
They may have made that argument just as they do now, but their own letter speaks for itself, I would say. And putting the question of whether they labeled it a variance request, that's 49 versus 51 to the side, even as to the Regulation 51 aspect of this, the record's clear, and the record before the Board of Health was clear, that they did not meet the requirements for a variance from Regulation 51 because of the setback restrictions. But again, under Title V jurisprudence, that is a question, so long as there's some evidence in the record, and again, there was ample evidence in the record that they did not meet the setback requirements for 51, that is a question for the Board of Health. And where there is that evidence, there cannot be any conclusion drawn under the proper standard of certiorari review that it was arbitrary and capricious.
But the Board of Health seems to be saying it doesn't matter what they could have shown, except on the variance, that under this regulation, it mandates tight tanks. So whatever showing of feasibility or whatever, how many atoms of nitrogen are coming out, none of that matters. Let's say hypothetically we were to disagree with the board's interpretation of its regulations, which is ultimately a question of law, and that it's a discretionary standard. What is the standard that under that interpretation, what is the standard that the board should have applied?
Well, and I think it's still the same standard that it ultimately did apply. It looks at the environmental concerns as laid out in the first 3 paragraphs of Regulation 49 and says, what is the best thing for the environment here? And as applied in this circumstance, the board, exercising its discretion as it may as the local administrative agency, can say, you have a tight tank, which is 0, or you have an IA system, which is 14 or whatever. Here, we want 0 because of the specific environmental conditions in the tight tank district across the bridge. Unless there are any questions, I'll rest on my brief.
Thank you both very much.
Thank you, Your
Very
Honor.
interesting case. It is now submitted. Our next and last case of the day is 2023 P391. THOMAS JALKUT versus the Woodward School for Girls, or more exactly, the city of Quincy. As we're all preparing, I just want to say it would be helpful, Mr. Timmons, to hear an update on the status of any eminent domain proceedings.
Certainly understood, Your Honor. At this point in time, there's been no appeal or Chapter 71 filing regarding the eminent domain taking order that was recorded. So that was recorded approximately 2 years ago. I did talk with an eminent domain attorney who was consulting with the plaintiffs earlier last year, and there was some discussion, but that's all there was.
And was there a pro tanto here? Or?
Well, I'm a little puzzled about that. I heard some discussion. There was a pro tanto, and it was voted, but I think the issue is that it was voted based on Quincy's understanding of the property. Quincy identified two parties in interest as the owners of the property, the city of Quincy and then the trust. So based on that understanding, there was a pro tanto paid.
But in any event, there's no litigation that you're aware of that has yet been filed on the amount of the just compensation. We can ask them when the...
Sure. Yes, that's my understanding, Your Honor.
Because it's my sense that that is essentially what we're fighting about now, is all going to be the assumptions that go into the amount of compensation that is going to be due.
I agree, Your Honor. That would be my understanding as well. The only remaining issue between the parties is this ownership interest, which at the time would have determined value. We no longer battle over the ownership interest because the city took title by eminent domain. So the dispute's been over for, well, since the spring, as far as the types of things that the interaction between the parties who didn't understand who owned what. But from roughly, I believe the recording was in May of last year. I beg your pardon, no, it was May of 2 years prior. And since that date, the city has owned the property.
Well, you say the city's owned the property the whole time.
All right. May it please the court, what the city's position is that there were two deeds, and that the second one conveyed the fee interest in the property. However, keeping in mind that these deeds originated in the 1820s, what happened was...
And the lawyer who wrote them didn't know what he was doing.
That's correct. I think he was burnt out from writing the state constitution, Your Honor. You know, what happened, well, what I will say is this. Obviously, the court's aware of a rich history here, and both in terms of litigation and the history behind everything that happened. My intention was to deal solely with the fact that we're here before you today based on when Quincy attempted to defend the fee interest that I just discussed with you. Our defense was summarily swept aside by the lower court applying issue preclusion. So we're really here solely on that. It's postured in that manner. And I'm happy to address that, but part of the issue preclusion argument is that all facts pleaded by the non-moving party must be deemed to be true. And the city of Quincy filed a counterclaim. Included in the counterclaim a description of the first deed from John Adams, which was 2 pastures, which essentially what he said is, you work these pastures, sell the wood, farm the land, do whatever it takes to generate some revenue. Because while he was kind enough to conceptualize indeed the land for this school and for the church that he proposed to be built, he did not have the funds to build them. And that's why there's a big gap between when the first deed was accepted by the city and the school actually opened.
Okay, but can can we just cut to the chase in terms of the issue preclusion? As I understand the argument you're making based on the difference in wording between the two deeds, so that if you looked as an original matter at the second deed, you could form an argument that the city's ownership interest in that property is different in kind than its ownership under the first deed. But the question is that water long under the bridge? I'm looking at the findings of fact that were made in the probate court case, and you don't have to get far. Paragraph 3 of the findings says, by a subsequent deed, we're talking about the second deed, President Adams made a further conveyance into the trust. That finding is that this property was given into the trust. And then in the judgment that resulted from these findings and rulings, the judge, specifically recognized the trust's ability to sell this very parcel. Why isn't the trustee correct that this issue is long resolved?
Your Honor, while the judge said that I'm not ordering the sale of the parcel, the city took that as the title is not being challenged or not at issue at this time. Had that attempted sale gone through, there were remedies for the city, which is sitting, or is the grantee in a deed across the street at the Norfolk County Registry of Deeds, and we file a memorandum of lis pendens saying there's a title issue. The property cannot be sold until this deed is addressed. The judge, when he made those findings and he made that order, did so in a complaint for an accounting. And when you go to the back...
By the time it was done, it was a complaint to replace the trustee, too.
Well, actually, complaint for an accounting, amended to a complaint for damages, and it included removal of the trustee. I acknowledge all three of those. None of those affect the fee across the street in the Registry of Deeds. They were all actions taken against the city of Quincy. The city, frankly, the city solicitor was delighted to be removed as a trustee. Municipalities should pick up garbage, education, public safety, do things that they're supposed to do. Quincy failed as a trustee, acknowledged that failure, and there were damages assessed as a result of that failure, and those damages were paid. There was no order that the land be sold. And interestingly, in this particular decision as well, I believe it's paragraph 185, I'd have to check the record appendix, but there's a Vigoda parcel, V-I-G-O-D-A. And there was a big dispute about that because at the time of the trial...
Because it was a money loser.
Right.
And
well, the city
The judge said the city had to shed that one.
Precisely. But what ended up happening was the judge decided, I'm going to order that the city pay damages, but so there's no double recovery, he ordered that the parcel be conveyed to the city. So the judge understood that title to real estate can only be transferred by that sort of conveyance. It's evidenced in the same decision with respect to the Vigoda parcel.
But there was a lot of other property we're talking about that was trust property, and since the city was deemed to hold it in trust, the substitution of the trustee affected a property transfer, correct? If it was trust property.
Understood, Your Honor. I see what the court's thinking. This is a trust that is the Adams Temple and School Fund Trust, and the Woodward School is an income beneficiary. There are real estate trusts and there are other matters. This is an asset of the trust in the respect that the lease income was paid to the income beneficiary. if you have an estate plan and you have, you know, a Microsoft or a Windows stock, that doesn't mean you own the company. It's an asset. The stock is an asset. One of the cases that's cited in the trustee's brief, Marcus versus Marcus, the court is very careful to explain that shares of stock, and I beg your pardon, let me see. The shares of stock are not assets of the corporation and were held in trust. The assets belong to the corporation, but the corporation was owned by the trust. So these mishmash situations can occur. The problem with what's happening here is that we're one to assume that simply because an income trust the trustee was changed, that the fee that was conveyed to the citizens of Quincy, to the municipal corporation's corporate capacity, that went with it. That's not what happened, Your Honor. And
But that, the question is whether that issue has been resolved effectively. And when you have findings of fact that's saying that this property was given in trust, you have a substitution of the trustee, and you have specific language where the judge is talking about the trustees selling this very parcel of land. Wasn't the time for the city to object in its appeal of that?
no, Your Honor, because nothing happened with respect to the fee in the land. When there was a lease agreement, another issue here is that the trustee has been the initiator of the actions here, not the city. We're being chastised for coming back for multiple bites at the apple. We've been defending the city's position here at all times, that being simply a fee interest in real property. The fact of the matter is that when you look at the administrative record, the 1972 lease is signed by the mayor of Quincy, and it's the city of Quincy signed by the mayor of Quincy, and then it is signed by the Adams Temple and School Fund trustees. So there's a distinction between the income that's being generated. Keep in mind, all this started because President Adams began with, here Quincy you get land, and here Quincy you get land with the fee interest included. The first parcels have to be used to generate income, and I want a trust set up. That's when the trust is set up on the first deed.
So in light of that, do you contend that Judge Langlois, in his judgment, made a mistake of fact when he determined that, I want to get the language correct, when he determined that the land was an asset, quote, in the Adams Temple and School Fund?
Well, this is an issue for me because we end up, how many angels are dancing on the head of a pin, Your Honor? It is an asset in the fund because there's a lease that's paying income. There's a school that was built by the money that was generated through this fund. So it had always been the case.
But he explained that the asset consisted of both the property, the land, and the building on it.
Well, I don't know that, I think what he said was he was describing an asset of the trust. That's what he was doing. He was not describing land owned by the trust because there was never a reference to a deed. And had he referred to the deed, it would have been the deed that was in the counterclaim. And I have a very short period of time.
Can you just go back to my question, though?
Sure.
Do you contend that he made a mistake of fact?
Well, yes, he did, to the extent he said that the fee was transferred. Yes. And furthermore, he said at the back end of his decision, he has kind of a catch-all that this is very complicated and mistakes may have been made. But I think the critical issue here, And what was not addressed, and what I wish had been addressed, it would have made things easier, perhaps eliminated this trip, but it made it easier for me here.
There'll be other trips.
Was that the finding has to have a bearing on the outcome. So Judge Langlois made that finding, but what did he ultimately do? I'm not going to have you sell it, so the fee's not at issue. You're going to be removed as trustee, fine. That doesn't affect the fee. You're going to pay damages, and you're going to file accounts. Those are the three things that Judge Langlois ordered. Now, title to the property is not implicated at all. It's not essential to a determination of the narrow issue before the court at that time. And that's what I'm relying on. That's how the Jarrah's case, which is one of the seminal cases on this issue, was determined. So that's the point I'm trying to make, and it's difficult because I tend not to get out of the batter's box on this issue for reasons similar to what occurred here, that I do understand that it's difficult to see these types of things and not say, how simple is this? Well, my position, Your Honor, is that when you look at the language in the deeds that are cited in our counterclaim, they're a little different from the findings that were made by Judge Langlois. And I should have had the opportunity to develop those differences.
Okay, I understand your argument that if you, as an original matter, look at the second deed, you can treat it differently. I have a hard time seeing how you get from that to drawing the distinction you make between the land and the building that was built, a building that is no longer used by the Adams Academy, which, as you know, closed long ago, and is not used by the Woodward School. How does the ownership of the building inure to the trust, even under your theory?
Well, the benefit that inures to the trust is whatever income the building generates. And right now...
But nothing in any of the deeds dealt with the income from the second parcel. The first parcel was the income producer that would generate the funds for the construction of the school on the second building. And I'm trying to get the sort of intellectual coherence of how does that then differ between, oh, well, the school is owned by the trust, I mean, the school building, but the land is owned by the city.
In the 1820s, John Adams, who, when writing the Massachusetts Constitution, included a provision about a public education. Well, in the 1820s, he wanted a school built in Quincy on land he owned to provide for education. This happened to be all boys. Fast forward now, and all kinds of things changed. That school opened, closed, it failed. The city of Quincy initiated a cypre petition and brought Woodward School in and said, let's have the money go there because this is the intention. So since that time, the property has been generating income.
Not much.
Right, the sordid history of that we'll skip past. However, that's what Woodward School, if you go back to 1953, what are they entitled to? Woodward School is entitled to income generated from this property. Now, that includes income from the sale, but that sale has to include the taxpayers of Quincy, who were holders of the fee in the land.
Counsel, I'm afraid you're 4 minutes over.
Well over, right. And thank you for indulging me.
Thank you very much. We'll hear first from the trust.
Good afternoon, Your Honor. May it please the Court, my name is Nelson Apjohn, and I represent the appellee, Thomas P JALKUT, as trustee of the Adams Temple and School Fund. With me this morning is Attorney Blessington, who represents the school, and if it's with the Court's permission, I'll take the first 13 minutes, or 12 minutes, and Mr. Blessington will have the final 3 minutes. I'd like to return back, taking your advice this morning, to get right to the facts, get to the heart of the matter, given the small amount of time, and deal with actually the facts of this particular matter. As the court correctly recognized, Judge Langlois, in paragraph 4 of his findings of fact, said that as of July 1822, by 2 deeds, John Adams had conveyed into trust the Adams Fund, and later named the Adams Temple and School Fund, over 161 acres of land. He wasn't talking about income, he was talking about a conveyance of land. And Justice Milkey, I think you said, isn't it water long under the bridge by this point to try to come back and contest that fact? It is, and as Justice Wilson found in the Superior Court, the time for contesting that fact was back at the time that Judge Langlois made his findings, and that was the time to challenge it on appeal if they disputed it. They didn't do that. They appealed to the SJC on other issues, but there was no dispute. This is a newfound claim separating the interest in the land from that of the building.
Could you tell us with great particularity why that was essential to the judgment?
Yes. The Woodward School brought 2 actions against the Quincy as trustee. The first was for an accounting. The second was for breach of fiduciary duty. In the accounting, and Justice Wilson said, the threshold issue for both claims, what assets did the trust have, and how did Quincy as trustee handle those assets? So for the accounting, actually the town of Quincy, or the city of Quincy, actually in their account had the Adams parcel as part of the account of the trust. As the SJC held in the Marcus case, the beneficiary in an accounting is entitled to a complete and full accounting of the assets held by the trust, and also with mathematical certainty what is the balance of the funds that are being held by the trustee to the beneficiary. So it's certainly essential to the accounting. And under the Jackson versus United States and Guarantee Fund case, an accounting is giving preclusive effect as issue preclusion as to the findings of the
So
accounting.
you're referencing the $1.885 million referenced in paragraph 19 of the judgment.
That's right, Your Honor. And that's where he says that's the most valuable asset of the trust, the Adams Fund Trust.
In the Adams Temple and School Fund,
Yes.
is the language.
Yes. And he goes on, I believe, into the next paragraph and says, I'm not telling the successor trustee what to do. And I think this whole thing has been somewhat misconstrued, that what that direction is. He's saying, I'm not telling you what to do with that parcel, but I want you to act prudent with it. If that parcel did not belong to the trust, he was in no position, the judge, to direct the successor trustee to do anything whatsoever. But he's saying act prudent with it because, in fact, Quincy did not act prudent with it. They leased it at below market rates to the Quincy Historical Society.
With the SJC's permission.
Yes, but that gets into my judicial estoppel if I have time, Your Honor.
But can I?
Yes.
While we're on that paragraph of the decree, Judge Langlois also said the trust should preserve it to the extent feasible, or words to that effect. What do we make of that? This, of course, may not be this appeal, but the next appeal. But from the trust perspective, you seem to be making an assumption that you are now free to sell it free and clear of any preservation
Well, of course, this whole action before you started from a petition by James Giacomo at the time as trustee to the single justice for permission to sell the land at that. And we had the right under a prior decree to go back to the court if things changed in order to seek permission to do so. And that's why the way things had come with respect to the value of the property, that was the decision the trustee made, was to seek permission to sell it.
No, I understand all that,
Okay.
but the question is, you know, in terms of when you eventually get to the eminent domain litigation, which I understand has not yet been filed, if we were to rule in the trust's favor in this case, then presumably the next battle is going to be over whether or not the market value of $4 million, whatever it is, you know, is the proper number, or given that Judge Langlois said you should preserve it to the extent possible. And by the way, it's another way, one could look to explain why the SJC approved a lease at $100 a month. What's the trust's position?
Trust's position is the issue of ownership, for purposes of this case, relates back to the taking. Who owned the land at the taking?
I understand our task may be limited.
But at that point, it doesn't matter what our desire is or the trustee's desire is with respect to the land. It's a forced sale of the land. So now it's a situation of compensation. And I don't know if the SJC would have approved the lease or the sale of the land to begin with, but we don't even have that option. It's been taken from the trust. It's a forced sale.
I understand, but am I correct to assume that the trust position in the MDO context is going to be that it gets to value the land at its full market value, free of any historic interests?
Yes, I think going back to that paragraph that you referenced, Your Honor, it says he's directing the trustee to be prudent with respect to the parcel, and he's not saying one way or the other when I'm telling you to sell it or not, but he doesn't say don't sell the land, maintain the land.
But he does go on to say it should preserve it to the extent feasible.
He says in coming years take such action as is prudent with regard to the property in keeping with the interest of the income beneficiary while preserving to the greatest extent possible the historic and unique nature of the Adams Academy.
That's my point.
Okay. Right.
The issue that this case raises is a narrow one.
Okay.
That we will answer one way or the other. I'm trying to get the parties thinking about the next case, and it would be sad if the parties kept fighting from here on.
It's been a long fight, and I think in our position resolved a long time ago with respect to ownership, but that's where we are. And just going back to the essential to the judgment, fiduciary duty, there was a finding by the court that there was a breach of the duty of loyalty of the city of Quincy with respect to leasing the land at nominal values. And that raised, I think, Justice Milkey, the decision that you talked about, and given the interest of time, I'll focus on judicial estoppel, because I think that is an equal grounds for upholding the judgment of the court. Judge Wilson did not have to reach that, given the fact that he found that issue preclusion applied.
Before you, as you enter into that, I wanted to ask you about that. Can we, on appeal, make a finding of judicial estoppel? Isn't that kind of a discretionary thing for the trial judge? Wouldn't we have to, in other words, wouldn't we have to remand it for that as opposed to us making a determination?
I don't think so, Your Honor, because it's my understanding that the appellate court can uphold a judgment on any grounds that are available to it. It doesn't have to be decided first by the trial court.
But like issue preclusion is more, and claim preclusion, those are more automatic. You can look at, you can, well, they're not, maybe not automatic, but you can figure out what was already decided. Whereas a judge, a trial judge would have the discretion not to apply judicial estoppel.
Well, there may be discretion, but again, the facts aren't disputed as to what, there's no factual finding that's necessary in the sense that after the Judge Langlois' findings, the successor trustee, Trustee DiGiacomo, brought a claim against Quincy based on the breach of fiduciary duty for damages in leasing the property to the Quincy Historical Society at below market rents. Quincy defended itself based on its actions in 1971 as trustee to go to the single justice seeking authorization to make that lease. In 1972, it received that authorization from the single justice authorizing the lease to the Quincy Historical Society. As Justice Langlois found in 1972, Quincy leased both the building and the surrounding grounds of the building to the Historical Society. So there again, there's a finding that the building was owned by the trustee. So now when Jim DiGiacomo as trustee brings his action, Quincy defends itself as trustee saying, we have no liability for breach of fiduciary duty because we received permission from the single justice of the SJC in 1972 to enter this lease. So basically, judicial estoppel, of course, applies where you have a party take an inconsistent position with that taken in prior litigation, I guess is successfully taken in prior litigation.
What is the inconsistency?
The inconsistency is to come in here and tell you that they own the property outright, not as trustee as we contend, but yet they defend that claim that Jim DiGiacomo brought before the SJC saying, we received permission as a trustee in order to make this lease. So on one hand, before the SJC, they say they're the trustee. They successfully defend the action as trustee. They avoid liability as trustee. And as the SJC held in that case against Jim DiGiacomo is that the 1972 adjudication arose from Quincy's exercise of the long-established privilege of a trustee to seek approval to protect the trustee from future liability. And now they're coming before you and saying, we didn't own the land as trustee, we own the land outright. They wouldn't have that privilege before the SJC otherwise.
But aren't they, it's not entirely clear to me what the city is arguing in terms of its responsibilities to the trust vis-a-vis this parcel. But they seem to be acknowledging that there are some trust responsibilities growing out of its ownership of this parcel, but they're saying that's not inconsistent with them owning this parcel in fee. And it's, those two ideas lie in some tension, but I'm not sure they're completely inconsistent.
I guess I would say I share your difficulty in understanding the city's position, given the fact that Judge Langlois held multiple times in his decision that they held the land as trustee. As Justice Wilson said, you can determine that by making an easy mathematical calculation on the return of value that the city was getting for the lease, that it was below market value, but it was to the penny that he was using both the land and the building in his calculations with respect to the lease to the Quincy's Historical Society. And I'll simply conclude by respectfully requesting that the court affirm the judgment below. Thank you.
Thank you very much. We'll hear from the school.
Good afternoon. May it please the court. My name is John Blessington, and I represent the other appellee, the Woodward School for Girls. And by way of background, it's a small independent school that's been around since the late 1800s. It is, as Mr. Abchon pointed out, and Mr. Timmons, the sole income beneficiary of the trust. So what I'd like to do is just provide some additional context to what Mr. Abchon just argued, particularly as to why you should affirm Judge Wilson's decision, but more importantly as to why we took the extraordinary step of requesting fees and costs in connection with this appeal. When Judge Langlois made the determination that the trust owned the 8 Adams Street parcel, and he made that determination as to not just the building, but also the land. He looked...
At least he didn't draw a distinction between them.
No, well, he talks in terms of, it came up in the context of the lease, and it came up in the context of his description of the property. And this was all in connection with the accounting that he had ordered that was conducted by James McLaughlin as a special master. And so he not only looked at the deeds, but not only did he rely upon the special master's report, which talked about the accounting that had been conducted, but he also looked at other material as well. And this is one thing we wanted to bring to your attention. If you look at footnote 30 of his decision, which can be found on page 54, and it's in the record appendix at 413, he has a footnote in which and I'm going to read the footnote. As late as November 24th, 2008, the trustee apparently, which is the city at that time, believed that it, the trust, owned only one parcel of land. He says one parcel of land, i.e. 8 Adams Street, upon which the Adams Academy building was located, all right? Now, what's interesting about that, he then goes on to provide the site as to what the basis for that finding was, and it happens to be a letter. And here's how it reads in the footnote. See Exhibit 222, letter of said date from Kevin J. Madden, First Assistant Solicitor, City of Quincy to Special Master James A. McLaughlin, Esquire. So what do we have?
Can I just say, where in the record are you quoting from?
Oh, this is from, it's a Record Appendix at 413. It's Judge Langlois' decision, but it's page 54 of his decision, it's footnote 30. And actually, as you know, we adopted in its entirety Thomas Jalkut, the trustee's brief, and you can find it, a reference to it in that brief at page 33, footnote 14. So it's before the court. But Langlois took a look at that document, and what's telling about that document, what's important and compelling, is the letter is coming from Mr. Timmons' predecessor. It's coming from Kevin Madden, who at the time was the city solicitor. And he's saying, in no uncertain terms, that the Adam Trust owns, at that point in time, and this is as of November 24th, 2008, they only own one piece of land, one parcel of land, and that's the 8 Adams Street parcel. No distinction between building and land in that. And again, it's coming from the city solicitor of Quincy. So that combined with what Mr. Apjohn just discussed in the context of the 1971 request by the then trusting city requesting that they be petitioned the SJC to be allowed to lease the property to the Quincy Historical Society. Those facts, in my opinion, and the school's opinion, sort of raises this to the level where this appeal is frivolous, because now we find ourselves after 2011 when the decision came down from Langlois, in which, again, that footnote sits in there, and that document, along with the deeds and the accounting, which, as he spells out...
Counsel, your time is...
All right, I'll just conclude with... I apologize.
Can I ask one question that it might be irrelevant and stupid, but I'm going to ask it anyway. It might shed light for me anyway. When this complaint was originally brought, the school was pled in as a defendant, as an adverse party. Were your interests in fact adverse at the beginning, or was that just more a matter of formality?
I think it was more of, it's so funny you should actually, I was just talking to Mr. Apjohn about this morning, but yeah, no, I think what they did was the interests were still aligned, but the trustee at that point in time decided to file suit and put everybody, including the Attorney General, the Historical Society, and the beneficiary on notice.
But not the town.
What's that?
But not the town.
Well, not the town. But I would just say, if you would just indulge me, only because this case has gone on for so long. 13 years after Langlois' decision, we're still here fighting over who owns this property. It couldn't be clearer. Langlois put the final nail in the coffin on that issue, and we just ask that you send a strong message to the city that this has to end. And one last thing, there was a taking, but there was no just compensation, because under their narrative, they own the property. So they took the property, and they didn't pay anything for the real property. They only paid something for the building. Thank you for your time.
Thank you all very much. Very interesting matter. As I more or less indicated in some of my remarks, there are a lot of more issues the parties can still choose to fight about if they want to. I would urge them to put their minds and interests to work and to try to see, we're more than happy to resolve this case, which is the only thing in front of us, but it's time to resolve this matter. And if separate from whatever we do, I would urge, or we would urge the parties to keep talking, or to talk anew if that's new, and let's get this done. So, thank you all. That we are adjourned, and thank.
Hold on, Rice, please.
I was going to thank him, but.
Thank him by getting up.
Court is now to recess.